afternoon, we noticed there is some text in his direct testimony. It looks like a line got dropped out of, sorry, of a page on his direct testimony, and we didn't notice it, unfortunately, until late yesterday. So I'm wondering if you would prefer us to file an errata, or would you like us to just deal with it when we present him?
Why don't you just put the line in,
Okay.
unless there's an objection,
All right.
no need to file new
Okay.
paperwork.
All right.
Yeah, but why don't we just do that? You're just going to have to make sure that if that's the way that it's fixed, that that you put the corrected version into the Dropbox so that Allison will have the correct version for the record.
Will do.
Okay,
Yep. All right. Thank you.
thank you. What about anybody else? Any other procedural matters we need to deal with before we go on our record here today?
Morning, Your Honor. Can I ask a couple of
Hello there,
questions?
Mr. Dubois, who I still, after a few years, want to call you Dubois.
And that is actually completely okay. So we can do that. Have we talked about that? I have a mix in my family, so they're both correct.
Okay, very well.
Um,
Go ahead, sir.
Yeah, two things. One, I would like to, if it's okay with you, sorry, have a second device that's with me also logged into the Zoom. I've had some issues with being dropped from the network on one device or the other. So I'd like to just keep one
You
logged
pay
in.
your internet bill?
It's not my internet bill, but yeah.
I'm kidding you.
I think an internet bill has been paid. But
and internet bill has been paid. Yeah.
Yes.
No, that's one of my favorite things when we have a problem here is like, okay, did the P&M bill get paid?
Yep.
What's happening here?
Yeah, so hopefully I can just wake up. If that happens, which I hope it doesn't, I can just wake up the other device and not
Okay.
be
So
disrupted.
is that who's in the waiting room as SPS witness?
It is not yet. That would be, I
Okay.
think, Ms. Trammell.
No, Miss Trammell is already,
Oh, okay.
I already have her in here.
I don't think you need to admit that attendee yet, Madam Hearing
Okay.
Examiner. That's just our secondary witness from here in Denver. Ms. Trammell is in Amarillo at a different location. So we have
Okay.
our additional witnesses who are in Denver with Ms. Hopkins and I. And so when they come to testify, they will join from that name.
Okay, very well.
We were just testing the technology and making sure it worked.
Okay, excellent. Appreciate that.
Oh,
All
and
right, there's Captain George.
Your Honor, second item on being on the Zoom and on camera.
Okay.
Obviously, SPS has 3 attorneys who have entered appearances, and our theory, if it works okay with you, would be one certainly logged in at any time, but not requiring that all 3 of us be on at any given time.
Oh, come on. The more the merrier.
We will absolutely all join the party if you would like.
No, that's fine. That goes for any of the parties with multiple attorneys. I realize, like I say, I think I mentioned yesterday that the cases, I think at least for the signatories, has become less involved, and you've probably moved on to other things. So again, as I requested yesterday, just as long as you have one attorney designated for questioning of a witness, as long as that attorney is available, then that's fine with me.
Thank you, Your Honor.
Looks like we've got about 5 minutes, so if anyone needs to go do something, get your water, hot tea, whatever. And we know the rules. Don't want you eating on the YouTube. Think that would be bad form. But obviously beverage is acceptable. Okay, that must be your other. I just got you again.
That is.
Okay. Okay, I just got the little screen or little prompt that we are YouTube live. Okay, now I've got another one that says SPS attorney.
I don't know who that is. One moment.
Okay. Put him on the YouTube. Excuse me.
Madam Hearing Examiner, that was just another test for the Denver office. So no need to admit we've removed ourselves with those
Okay,
SKS names. Sorry about that.
thank you. No, just wanted to know.
Thank you.
Okay, we are about ready to start. Allison, how are you doing?
Ready to go.
Mr. Elliott, will you tell Ms. Reno that she's going to have to listen on YouTube, please?
Yes, ma'am, I will.
Thank you. All right. Well, if no one has any procedural matters that they want to add to the list, I believe that we can go ahead. Allison, our court reporter, is ready. So I will begin. Good morning. My name is Elizabeth Hurst. I am the designated hearing examiner for case number 2400270 UT. This is in the matter of Southwestern Public Service Company's application for approval of continued use of its fuel and purchase power adjustment clause, Fppcac, using a monthly adjustment factor under NMPRC Rule 550 and for implementation of certain matters through the Fppcac. Today is the date, time, and place set forth in the procedure order that I issued in this case on February 25th, 2025, to have a hearing in this matter. Along with me today is our court reporter, Allison Hoyman. Should you need anything to do with the transcript, you'll need to deal with Allison yourself. I just want to announce for the record that our hearing is also being viewed live on YouTube, and it would behoove you when we have breaks and or lunch and recess to remember that, unless you want your voice and image to continue on during that time. I'd like to go ahead at this point and get our appearances for the record, beginning with you, Ms. Poole, for SPS.
Good morning, Your Honor. Stephanie Houle, Will Dubois, and Marty Hopkins for SPS.
Very well. Good morning. And I believe that I've lost my, there's my pre-hearing memorandum. I believe that the next in order of cross will go you, Mr. McMillan, for OPL.
Good morning, Your Honor. Michael McMillan for OPL.
Thank you, sir. And for New Mexico Large Customer Group, Mr. Stoffel or Mr. Rushoff?
Good morning, hearing examiner Hurst, Austin Rushoff on behalf of the New Mexico Large Customer Group, and yes, also joined by my colleague Nick Stoffel.
Very well. Good morning.
Good morning.
And I believe Captain George for FEA.
Yes, good morning, hearing examiner Captain Ashley George on behalf of the federal executive agencies.
Good morning. Ms. Drake for LES.
Good morning, Joan Drake for Louisiana Energy Services, or LES.
Thank you. Good morning. Mr. Elliott for NMDOJ.
Good morning, Madam Hearing Examiner Gideon Elliott for the New Mexico Department of Justice.
Good morning. Ms. Lynch for CCAE.
Good morning, hearing examiner Kara Lynch for Coalition for Clean Affordable Energy.
Very well. And Ms. Hank for staff.
Good morning, Madam Hearing Examiner. Katie Lang on behalf of the New Mexico Public Regulation Commission staff. And joining me also is Nicholas Rossi, who is also appearing on behalf of staff. Thank you.
Thank you. Good morning. And I believe that concludes our appearances for our record. Let me also say that upon review of the commission's e-docket information system, I can report that there were no public comments filed in this case. Additionally, pursuant to the procedural order, there were notice requirements which were fulfilled by the affidavits of publication, web publication, and mailing filed by SPS in this docket. And having reviewed those, SPS has comported with the appropriate notice in this case. We have a couple of procedural matters that we need to deal with before we begin the evidentiary portion of our case. And first, Ms. Lynch, I believe you have a request.
Yes, hearing examiner, I was requesting to be excused from the hearing. CCAE did not oppose the stipulation, and we will not be writing a post-hearing brief.
And it's my understanding, Ms. Lynch, that CCAE did not file any witness testimony. Is that correct?
Correct.
Okay. Is CCAE asking to be have their any
We're just
remaining
asking to
participation be excused, or are you asking to have your intervention terminated?
We're just asking to be excused from the hearing.
Okay. Is there any objection to CCAE being excused from the hearing? Hearing none, your request to not attend the hearing is granted, Ms. Lynch.
Thank you.
Thank you, and that's with the understanding that you're waiving anything, any cross-examination or potential oral argument on anything that might happen while you're not here. Do you understand
Correct.
that?
Yes.
Okay. Very well. Okay, you're excused, ma'am.
Okay.
Thank you.
Thank you.
And Ms. Drake, I believe you had a matter with regard to a line being dropped from the testimony that it seems more efficient rather than filing errata and new paperwork, that you're going to address that at the time that Mr. Gorman is called. Is that correct?
Correct, ma'am, and we will file a corrected version in the Dropbox. We'll upload it to the Dropbox, and for convenience, we'll redline the edits so they're easy to find, and we can also email to you and the parties the corrected version.
Okay, very well.
Thank you. And
Thank you.
sorry for the error.
That's okay. We'll deal with that issue later. So very well. I think with those procedural matters then taken care of, unless we have any other, I believe that we can go ahead and begin the evidentiary portion of our hearing with the presentation of SPS's witnesses. And I believe that pursuant to SPS's pre-hearing order, you intend to call Ms. Trammell first, correct?
That is correct, Your Honor.
Go ahead, Mr. Du Bois, or Ms. Houle, or Ms. Hopkins, whoever has this witness.
This one will be me, Your Honor. Thank you.
Oh, go ahead.
And yes, Southwestern Public Service Company, SPS, would like to call Brooke A. Trammell.
Ellison, would you please swear the witness in?
Ms. Trammell, would you raise your right hand for me, please? There you are. Do you solemnly swear or affirm the testimony you're about to give shall be the truth, the whole truth, and nothing but the truth?
Yes, I do.
Thank you.
Ms. Trammell, do you have, I'm sorry.
Go ahead.
The backup device was echoing. To drop it. Thank you. Ms. Trammell, do you have in front of you first what has been marked as SPS Exhibit 1, simply titled Application?
Yes, I do.
And to the best of your knowledge and belief, is that a true and correct copy of that document?
Yes, it is.
Do you also have in front of you what has been marked as SPS Exhibit 2, titled Notice of Filing of Affidavits of Publication and Web Publication?
Mine has a different title, but yes, this is Exhibit SPS 2, and it's our Notice of Filing Affidavits of Publication.
Ah, yes, thank you. And to the best of your knowledge and belief, is that a true and correct copy?
Yes.
And you have in front of you what has been marked as SPS Exhibit 3, direct testimony of Brooke A. Trammell as corrected via errata filed May 1, 2025.
I do.
And was that prepared by you or under your direction and supervision?
It was.
And to the best of your knowledge and belief, is that a true and correct copy?
Yes, this copy incorporates the errata that was made on page 50 of my direct testimony.
Thank you. And do you have what has been marked as SPS Exhibit 4, supplemental direct testimony of Brooke A. Trammell?
Yes.
And was that prepared by you or under your direction and supervision?
Yes, it was.
And is that a true and correct copy to the best of your knowledge and belief?
Yes.
And do you have in front of you what has been marked as SPS Exhibit 12, titled Testimony in Support of Non-Unanimous Comprehensive Stipulation of Brooke A. Trammell?
Again, my title is Testimony in Support of Comprehensive Non-Unanimous, different order, but yes, this is Exhibit 12, and this appears to be a full copy of the stipulation.
Thank you. And was that prepared by you or under your direction and supervision?
It was.
And to the best of your knowledge and belief, is that a true and correct copy?
Yes.
Your Honor, we would move SPS Exhibits 1, 2, 3, 4, and 12 into the record.
Excuse me. With regard to SPS Exhibits 1 and 2, is there a reason Mr. Du Bois thought we can't just take administrative notice of what's been filed in the record?
Absolutely no reason not to do that, Your Honor. Pardon the double negative. I appreciate doing it that way. This was just in case that was preferred.
Therefore, would SPS's preference be to request administrative notice of what's been filed in case number 24-00270?
Yes, Your Honor, and we could withdraw the motion as to SPS 1 and SPS 2.
Very well. Any objection to me taking administrative notice of the application that's been identified by Ms. Trammell as SPS's application in this case? Hearing no objection, I will take administrative notice of the application in this case. Any objection to me taking administrative notice of the previously referenced by me notice of publication affidavits
Ms. Hurst? I believe we have lost Ms. Hurst.
You're on mute, ma'am.
Whoa. So, Mr. Du Bois, the question is, did we pay our internet bill?
Madam Hearing Examiner, the last thing I have on the record is any objection to me taking administrative notice of the previously referenced by me notice of publication affidavits.
And then I said, hearing no objection, I will take administrative notice of SPS's filing of the affidavits of publication. Is there any objection to what has been? Well, actually, I went ahead and started to ask Ms. Trammell with regard to her direct testimony identified as SPS Exhibit 3. Ms. Trammell, if you were asked those questions again here today, would your answers be the same?
Yes, as corrected with the one errata item.
Okay. And do you have any additions, corrections, or deletions to SPS Exhibit 3?
No, I do not.
And if I am correct, the only attachment that you have to SPS Exhibit 3 is the testimonial record.
There were two.
There are two. The first one is your testimonial record, and the second is a chart entitled Monthly New Mexico Retail Fuel and Purchase Power Expenses during Reporting Period. And that's a one-page document. Those are your only attachments?
Yes, Your Honor.
And did you prepare those attachments yourself, or were they prepared under your direction and control?
Both. I have prepared the testimony list, and members of my team supported me in developing the graph that's included in attachment BAT2.
Okay, so you did in fact work on actually preparing your second attachment, and it's true and correct to the best of your knowledge?
Yes, Your Honor.
Okay. Thank you. Any objection to what's been identified as SPS Exhibit 3, Ms. Trammell's testimony as identified by her here today? Hearing no objection, SPS 3 is admitted. Ms. Trammell, with regard to your supplemental testimony that you've identified, it also has attachments?
It does. It has
And did you
two attachments as well.
Okay. And the first one, BAT-1, is entitled Forecast of PTC Costs and Benefits. And that's a one-page document?
Correct.
Did you prepare that attachment, or was that prepared under your direction and control?
Yes, it was.
And is it true and correct to the best of your knowledge?
Yes, Your Honor.
Okay. And what about your attachment BAT-S2? It says in the corner in tiny print, you have violated the I can't read it Elizabeth rule, Ms. Trammell.
I apologize. Proposed mechanism illustrated in monthly fuel 550 report.
Yeah, want to make that big enough so I can see it, because if I have to use this to read it, Not good.
Yes,
That's
Your Honor.
why I put in your notice that you can't go below 10.5, which is the footnote font that hearing examiners use. But be that as it may. Okay, you've identified this, and was this prepared by you or under your direction and control?
It was.
And it's true or correct to the best of your knowledge?
Yes. This is an illustrative example of our direct case. It's not reflective of what would flow through SPS's monthly factors pursuant to the terms of the stipulation. But again, this was attachment to supplemental direct testimony in March of this year.
And you were responding to requests that I had put in the procedural order with the filing of the supplemental testimony, correct?
That's correct.
Mr. Trammell, if you were asked the same questions, would you give the same answers to your supplemental testimony SPS 4?
Yes, I would.
Any additions, corrections, or deletions to that testimony?
No, Your Honor.
Any objection to what's been identified as SPS Exhibit 4, Ms. Trammell's supplemental testimony as verified by her here today? Hearing no objection, SPS 4 is admitted. SPS 12 has been identified as testimony in support of comprehensive non-unanimous stipulation. That's your testimony, Ms. Trammell.
It is.
And did it have any attachments?
I believe that this testimony attached the actual stipulation. But let me triple check.
Yes, it did.
Yes, BAT step 1. That is also, the stipulation is also signatories exhibit, but it's here as well as an attachment to my testimony exhibit 12.
Okay, do I need it in both places?
Well, we haven't talked about the signatories exhibit yet.
Okay.
Leave that to you and Mr. Dubois.
Very well. But the copy of the comprehensive non-unanimous stipulation is the one that actually got filed by SPS, right? And the other signatories.
Yes, I'm just verifying in my copy that I see the signature blocks on the stipulation, but yes, this is my attachment, BAT step 1 is the comprehensive non-unanimous stipulation filed, I believe, May 15th, 2025.
Mr. Dubois, do I need this? Can I take administrative notice of this?
Yes, Your Honor, that would work well. Thank you.
As opposed to having 2 copies of this in the record?
Yes, Your Honor.
I mean, I'll leave one if you think it adds to adds to the completeness of the testimony.
I myself am a fan of the administrative notice approach and just one document if that works for you. We were just being belt and suspenders.
I get it. Absolutely. Okay. Your testimony, Ms. Trammell, in support of the comprehensive non-unanimous stipulation. If you were asked those very same questions here today, would your answers be the same?
Yes, they would.
Any corrections, additions, or deletions to that testimony?
No, Your Honor.
Okay. Any objection to what has been identified as SPS Exhibit 12, and it's gonna be minus the attachment of the stipulation when it gets refiled with the court reporter? Hearing no objection, the SPS Exhibit 12 as identified to be admitted is admitted. Mr. Dubois.
With my apologies for doing too short a version of the litany, and thank you for completing that out for us. Nothing further introducing Ms. Trammell, and she's available for cross-examination.
Very well. Thank you, Mr. Dubois. It is my understanding that I guess I would like the record to reflect that pursuant to the SPS pre-hearing memo, FEA, LES, NMDOJ, and CCAE have all waived all cross-examination. Captain George, is that correct?
Yes, ma'am, that's correct.
Thank you. Ms. Drake?
Yes, that's correct. Thank you.
Thank you. Mr. Elliott?
Correct.
Thank you. And Ms. Lynch is, she's been excused. So with the proviso that was brought up yesterday by staff against any friendly cross, the order of examination that we have, Mr. McMillan, does OPL have any questions for Ms. Trammell?
No, Your Honor. And there may have been something missing from our pre-hearing filing. OPL waives all cross in this hearing.
Okay, I'll add
Provided
you to
that
the
we
waive.
reserve the right to cross if we believe it's necessary to clarify something that is brought up by a witness.
Okay, very well. I mean, I don't mind calling everybody's name for every witness, but if people are going to give me a blanket waiver, I'll just go ahead and enter that. All right, sir. Thank you. And for New Mexico Large Customer Group, Mr. Rushoff, or any questions for Ms. Trammell?
No questions for Ms. Trammell.
Okay, very well. Okay, so I believe that brings us then to staff. And it's my understanding that staff has some questions for Ms. Trammell. Is that correct?
That is correct, Your Honor.
Very well.
That is correct.
And if you'll just when you're going to do the questioning?
Yes, ma'am.
Okay. If you would just please, since she has multiple testimonies, if you would just make sure that you direct her and me to which SPS exhibit that you're asking about, I'd appreciate it.
Yes, of course.
Okay, thank you. Go ahead.
Thank you. Ms. Trammell, good morning. Thank you for your time.
Good morning.
Ms. Trammell, I am going to direct you to what has been labeled Staff's Exhibit PB 3.7. It is an attachment that was added to SPS's responses to staff's discovery questions. I believe it's for question 1-4. Do you see that?
Can you give me the exhibit number again?
It's it's been labeled Staff's Exhibit PB 3.7.
I assume this was an attachment to Mr. Brossi's testimony in opposition.
Yeah, so we actually filed it as a separate exhibit, actually.
Okay. Trying to find it. I assume I have a copy.
Now, in the Dropbox, okay. Okay, there's the exhibit. There it is. So it's not, the testimony does not have the attachments.
That is correct.
So you're saying staff. Okay.
He references these exhibits in his testimony, but it was my mistake. I thought it would have been more prudent to separate them out so we can authenticate them as we go instead of waiting for Mr. Percy's testimony, which I'm assuming is not going to be today.
Okay, is this it?
Yes, ma'am, that is the one.
Okay, go ahead. Do you see that, Ms. Trammell?
I do, Your Honor.
Okay, go ahead.
Ms. Trammell, you're familiar with this, correct?
Yes, I'm familiar that this was an exhibit. I believe it's an exhibit that may have referenced a discovery response in this case that I did not sponsor.
I'm pretty sure you did. Let me it's for in response to staff's discovery question 1.4.
Do you have that?
I do. That question was sponsored by Mr. Malley and Mr. Baumgarten.
Okay. I will have them authenticated. And this exhibit, do you see the line 11 on there? And the
I do.
table? Can you tell us what that disallowance is?
Rather than speculate, that would probably be a question that Mr. Malley could answer with certainty.
Isn't it true, Ms. Trammell, that that disallowance, it's really not a speculative thing. It's actually a pretty known fact that that is the result of the final order in Texas PUC docket 55973.
Objection.
And your objection, Mr. Dubois?
I think we just established a lack of foundation.
Ms. A?
Ms. Trammell was unable to answer what that line represents in the first place.
Ms. A?
I will withdraw the question and direct it to Mr. Malley instead.
Good. Go ahead.
Yes, okay, I am going to direct you to what has been labeled staff's exhibit PB 3.6.
Okay.
You are, of course, familiar with this document, aren't you?
It appears to be an order from a Texas proceeding.
Yes, which you are familiar with, aren't you not?
Yes, this was SPS's 2023 Texas Fuel Reconciliation Docket.
Your Honor, staff moves to admit what has been labeled staff's exhibit PB 3.6.
Objection, Your Honor?
Yes, go ahead.
Object both based on relevance and on scope, and let me know if I should elaborate first or not.
Go ahead.
We recognize staff has raised a issue that they have relative to the stipulation as to the scope of it relative to certain issues that are not contained in it. Okay. And we believe first, a Texas order, this Texas order, is not relevant to this proceeding, and that Ms. Trammell is not testifying as to the subject matter of that order. There is a passage in her testimony that is addressed to what could have been contemplated by parties in that case, or what is not known to be contemplated, but we believe this would be outside of the scope.
Your response, Ms. Hang?
Yes, as to relevance, this is very relevant. It is the crux of the matter in some of the issues of the new adjustment request that SPS is making in this filing. And it is directly related, in fact, to the wind turbine hail and Sagamore issues that staff has raised. And as to the scope, it is firmly within the scope of the request that they are making. And it's the fact that it's from Texas is not a disqualifier, since the facilities in question is it affects both Texas and New Mexico, and was the result of a CCN order and commission allowance in a prior New Mexico PRC case.
Mr. DuBois?
Your Honor, I'm afraid I'm still not following. If I'm understanding correctly, there seems to be a idea here that there's some argument as to the merits of that case, or as that case relates to this case. And we do believe a merits argument as to a disallowance in a Texas case is outside of the scope of this case. We understand that staff has asked that perhaps merits be considered in some venue, but we do not think this is the venue.
Madam Hearing Examiner, may I? If I may?
Yes, please.
To be clear, it is not just a Texas case. The calculations that come out of this case directly affect New Mexico because of the nature of how Hale and Sagamore are connected to both states. To say that whatever is happening in Texas is not the scope within of this venue in New Mexico is, well, factually inaccurate. Because, let me put it this way. The resulting calculations in that state directly affect New Mexico, and has been. And to say that it's beyond the scope of this case, when SPS in fact put this as an issue, let me say that, strike that. To say that it doesn't affect New Mexico because it's in Texas, it's just not. It doesn't follow, because the facilities in question affect both states. I guess I'm not seeing why anyone would argue that it's meritless, because it's clear that Hale and Sagamore both affect both states, and the calculations that happen in one state necessarily bleed through to the other state, which is New Mexico.
So basically, what you're arguing, Ms. Hang, is that it's staff's belief that consideration of Hale and Sagamore and the some of the issues surrounding certain parts of the stipulation in that case, staff believes are directly related to the fuel and purchase power clause continuation determination in this case?
Well, Your Honor, I'm glad you brought that up. Not to the FPPCAC application, which is what we're all here for, but it relates directly to the proposed new adjustments to calculations that SPS is proposing. Which, you know, in themselves, perhaps that you can argue that they don't relate to the FPPCAC, but since it's already in the application, they're here, so we need to address them.
I don't know that that's correct, Ms. A. You know, just because somebody throws spaghetti up to the wall to see if it sticks, you know, this case isn't an all-encompassing of everything, which sort of begs the question about if staff found out about a proceeding that was going on in Texas, if staff believes that it's such an important issue, why hasn't staff filed a proceeding, a request for a show cause or some other type of investigatory proceeding in this case? Not in this case, with the commission outside of this case to address these issues?
It came, we discovered it during the course of preparing for and reviewing the application. And it was decided that since it was already put in the application, it was best addressed in the application, just if nothing else, to preserve and be judicious about the efficiencies and staff time and resources of the commission as well.
Very well. Anything further, Mr. Dubois?
Your Honor, yes, please. First, I'm not aware of this being in the application. Second, we do not see or understand the relationship that's being asserted between this and the actual requests in the application. And third, we're not asserting that this subject matter that Hale and Sagamore have no relationship to New Mexico. They do have a relationship to New Mexico. Our point is as to the scope of this proceeding.
Madam Hearing Examiner, may I?
Yes, please.
Yes. Hale and Sagamore directly relates to the proposed new adjustments with regard to off-system sales margins. And I know, let me put it this way. If the breadcrumbs are not directly relevant, it's not, if the breadcrumbs aren't directly and easily apparent, it's in the manner of how the application has been set up. And so, of course, it would be difficult to find the breadcrumbs if you are not looking for it or you're not looking at it. But it's staff's contention that the Texas case directly affects the request regarding off-system sales margins, which is an issue in the application, and it is extremely relevant and important to consider because it goes down to how certain denominators in calculations are affected, particularly with the previous commission case, 1744, where the CCN in that case was provided under a calculation that potentially is different now per the monthly filings of SPS.
Your Honor, may I one more time, at least?
You're saying the SPS has changed the calculations from the stipulation?
Yes, the denominator has changed. And this is
In,
something,
in this
monthly-
case, okay, they've changed something to the stipulation in their reports in this case.
correct. Of course, I
Go
can't
ahead, sir.
testify to that, but I cannot
Well, no,
testify
you
to
can't
that.
testify at all, but it's staff's allegation that one of the reports that SPS files is different than what was agreed to in the stipulation.
In 1744, yes, that's correct. It's not an allegation. When we do testify, we have calculations that we can testify to.
Go ahead, Mr. Dubois.
Thank you, Your Honor. What I thought I understood, or what I thought I heard as to the last point, had been that this was part of the scope of SPS's request in this case as to off-system sales margin, which Hale and Sagamore are explicitly not part of the scope of that request. That request, it was as to resources since Hale and Sagamore and not inclusive of Hale and
Right.
Sagamore. And again, the testimony in this case as to relief that staff is seeking related to Hale and Sagamore and the issue we seem to be talking about right now was explicitly offered as a request to discuss this issue substantively in either a subsequent proceeding in this docket or a separate proceeding. So I still come back around to not following how a merits argument is relevant at this time in this case.
Okay, very well. As to the specific request to admit staff exhibit PB 3 point, was it 7?
It's 6. Yeah.
I'm gonna deny that request. I am not going to introduce orders from other proceedings, especially an out-of-state proceeding, as an evidentiary exhibit. If you would like me to take administrative notice of that document, at the appropriate time where said document could be authenticated as to source and completeness, I would consider doing that at that particular point in time. Additionally, let me say, so I've ruled on that, but for the record, Ms. Trammell, if you would look at SPS Exhibit 12, page 37,
I'm there.
you do in fact reference the Texas Fuel Reconciliation docket that purportedly was just discussed. Is that correct?
I'm referencing Mr. Brossi's testimony that references that proceeding. Yes, that's correct.
Okay, so there's just one proceeding.
Yes, Your Honor.
That staff's concerned about and that SPS has participated in, right?
I believe so, that 2023 Texas Fuel Reconciliation case.
Okay. And as per the clarification, that Mr. Dubois made, not referencing any legal argument that your counsel has made, Ms. Trammell. On page 39 of SPS Exhibit 12, in your testimony, you do say SPS does not object to apparently an issue from the Texas proceeding being reviewed in some context. Is that your testimony?
Yes, and that's based off Mr. Brossi's recommendation, at least that I interpreted from his direct testimony, that is recommending the commission review this in a future proceeding, or in a proceeding, in a subsequent proceeding, or in a future proceeding, or in some proceeding. It's my testimony that the commission can review matters in proceedings.
And that you're not objecting to it, right?
Correct.
Okay. Thank you. Go ahead, Ms. Hang. Let's
Thank you,
see.
Your Honor.
Allison, how are you doing? Should we take a 10-minute break or?
Whenever it's convenient for you, I'm fine.
Okay, well, let's go ahead and take a 10-minute break at this point, and we'll come back and let Ms. Hang ask her questions after that. So I have down here on the screen, let's go by the phone. The phone says 10:24. So let's come back at 10:34. So remember that the YouTube is on. It will not be turned off. and we are recessed for 10 minutes. Thank you. Okay. Are we good, Allison? Awesome. Thank you. All right, we're back from a recess. Ms. Hank, if you'd like to go ahead with your questions for Ms. Trammell.
Yes, ma'am. Thank you. Ms.
Go
Trammell,
ahead.
I am, can you hear me?
Yes.
Okay. I am going to direct you to your direct testimony, page 13. Is somewhere it mentions, well, tell me when you get there, unless you already memorized it.
I'm sorry, which page did you ask for?
13.
I'm there.
Okay. You mentioned nameplate capacity. Do you see that?
I do.
What is that?
It references here installed nameplate capability of a certain number of megawatts. So that represents the nameplate capacity of the 8 thermal generating facilities in Texas, New Mexico referenced in that section, that sentence.
Right, but what does substantively, what does that mean?
A nameplate rating is referred to as the kind of manufacturing nameplate capability of a generator, as opposed to a generator's accredited capacity.
What's the difference?
Different accreditation methodologies assign, for capacity purposes, different capacity accreditations for different types of generation technologies. Generally, reliability entities may have different accreditation methodologies for different types of resources.
Let me re-ask. I guess I'm not asking it correct. Okay, so nameplate isn't it true that nameplate is what a device can maximally produce as manufactured?
Potentially, there's a lot that factors into maximum production.
Yes, there is, but in essence, a nameplate means, for example, I have solar power on my roof, and the nameplate is I don't know, some 300 or 600, I can't remember. That's the nameplate. That's what wouldn't you agree that that's what my 6 panels can maximally possibly produce given conditions are great and all that, correct?
I think a nameplate rating is a rating from a manufacturer. I don't think it directly results to maximum production.
Yes, but they are saying that it's possible that I could produce 300, whatever it is that I produce, kilowatts, megawatts, whatever. Correct?
Objection.
Potentially.
Yes. I will move on. And I will saying in your direct testimony, page 55, line 15, you cite to a prior New Mexico Commission Order 17-00044 UT final order. Did you see that?
I do.
Your Honor, staff moves to have the final order in New Mexico PRC case number 17-00044 UT is for administrative notice.
Ms. Trammell, in SPS, it's Exhibit 3 on page 55. Under heading 8, off system sales margin sharing. Line 12, the questions posed. How are SPS's off-system sales allocated for current resources? You begin your answer on line 13. About crediting customers with 100% of jurisdictional off-system sales margins subsequent to the final order in case number 17-00044. Starting with the effective date of base rates in case number 17-00255. That's your testimony?
Yes, Your Honor.
Did you participate in case number 17-0044?
I was not a witness.
Are you familiar with case number 17-0044?
Generally, yes.
And are you familiar with the final order in 17-0044?
Yes, Your Honor.
Any objection to taking administrative notice of the commission's final order in case number 17-0044 UT, which was entitled
Your Honor, are you asking me?
Nope, looking
okay.
at
Okay.
InfoShare. No, I'm actually doing your job, Ms. Hang. You need to authenticate and lay the foundation appropriately for any request, whether it be an evidentiary request for an exhibit or an administrative notice or some other type of ruling. Let's see. Ms. Trammell, when you refer to the final order in that case, were you referring to the final order adopting certification of stipulation with modification issued by the commission on March 21st, 2018? If you know.
Your Honor, really this sentence is referring to a period in time, and the inflection point for when SPS's off-system sales margin sharing changed was actually the effective data rates from 17 to 55. My reference to 1744 in this sentence is really just to illustrate that the rate case and then subsequently the decision in the effective data rates in case number 17-00255 was subsequent or after the WIN CCN.
Your testimony, you referred to an order, just asking you which order you were referring to. There is no document entitled final order in 17-0044 UT.
I believe the title you referenced is the final order, or the last order in that case. I believe there were a couple gyrations of orders through that proceeding.
Well, and you've been a witness long enough to know, Miss Trammell, I'm perfectly fine with a I don't know answer. If, I don't want you to accept it because I read it. I
Fair
want you
enough.
to accept it because it's the answer to your testimony. It's what you looked at.
Yeah, I don't recall
I'm not trying to put words in your mouth.
I don't recall the exact title of that order, Your Honor, at this time.
Okay. All right, then I'm going to deny the request to take administrative notice of 17-00044 order because the witness cannot identify the order she was referring to. Go ahead, Ms. Hang.
Thank you, Your Honor. Ms. Trammell, same place, page 55, line 15. You mentioned that order in 1744, and to discuss prior to that order, SPS had retained 10% and then crediting 90% of the off-system sales margins, correct?
That's correct.
And since that order, SPS now credits 100% to customers, is that correct?
Since the effective date of rates in case number 17255, SPS credits 100% of off-system sales margins of the resources at that time to customers. Yes.
Yes, okay, let me, bear with me here. Just gonna pull up something on my screen. Isn't it, well, even though we can't, track down the correct title of the order, you do reference, the final order in 1744, and isn't it true that per that order, the commission ordered SPS to track combined annual energy production from the Hale and Sagamore and guarantee minimum net capacity factor of 48%?
I don't recall the exact language of the order. Do you have a reference you can direct me to?
I hesitate because I couldn't, hold on. So I am pulling up, for clarity sake, I am pulling up what is entitled Final Order Adopting Certification of Stipulation with Modification. Is that? Would that be something you can look up, Ms. Trammell?
No, I don't have the ability to look up orders right now.
But you did study this, did you not? To prepare your direct testimony? I mean, you cite it.
Yes, I'm familiar with when SPS began crediting 100% of jurisdictional off-system sales margins to New Mexico customers.
Okay. So I am going to the order that I am referencing as previously okay, since you can't look up that order and I can't administratively notice this, generally 1744 ordered SPS to require a net capacity factor requirement, right?
Generally, part of the stipulation in the WIN CCNs established a combined average net capacity factor for the Hale and Sagamore facilities.
So that's a yes?
It's a clarification of your answer. You didn't refer to it as a combined net capacity factor, and you didn't name the facility. So I was adding those details.
Yes, but with those details added, that's a yes, right?
Generally, yes.
Yes, and it was a general question. Isn't it
You
also
can't
true?
testify and don't repeat, Ms. Hang, okay?
Yes, Your Honor. Isn't it also true that per the stipulation, should the minimum guarantee number of the net capacity fall between a certain level, SPS is to credit that to fuel expenses?
Generally, yes. There's a calculation that will be reviewed, and that's referred to as a recapture or a payback.
Okay. Ms. Trammell, can you explain what net capacity factor is?
I don't.
What's your objection, Mr. Du Bois?
Relevance, Your Honor.
Ms. Hang?
Your Honor, this is the very thing we are talking about now.
Can you reference in her testimony where she talked about this, Ms. Hang?
Yes.
Miss Wool, you're in, right?
Your Honor, I am. Thank you for readmitting me.
Okay. Thank you. I got a message that you got kicked out, so I was trying to find that. Go ahead, Ms. Hang.
Yes, it is on the PDF page number 26 of 43, line 8 to the direct testimony of Ms. Trammell.
Page 26?
Yes, 26 of 43 of the PDF numbering.
I have a printed version of hearing exhibit 3.
So that will be 23.
Thank you. Okay, we were talking about off-system sales margins. Page 23 of my direct testimony is discussing tax-related items for the new solar facilities.
Yes.
Is that the page you meant?
Yes, and it's particularly on line 9 of page 23 of the paper.
Okay, that's referring to a gas-fired generation station.
I'm sorry, Your Honor, do I still have a objection pending, or was that ruled on?
Well, I'm trying to figure out whether or not you have a scope or relevance objection.
Your Honor, if it's my turn to answer, the line 9
Hang
does
on,
not
nope,
reference.
nope. Your counsel does not want you to answer until I.
Thank you, Your Honor.
Let's see. The question was, Ms. Trammell, can you explain what net capacity factor is? And you objected, and you have a relevance objection to her explaining what net capacity factor is. And I asked Ms. Hang to identify where she talked about that in her testimony, and we're at page 23, line 9. Is that your reference, Ms. Hang? You're muted.
I'm sorry. No, that was wrong. I was in the wrong window. I will direct Ms. Trammell. So I will strike that question. I will ask a new one.
Okay, go ahead.
Ms. Trammell, on page 63 of your direct, you talk about on lines 14, starting at lines 14, what is accredited capacity? Can you explain that, please?
Accredited capacity refers to the amount of capacity that a reliability entity assigns a generation technology for resource adequacy purposes. As I mentioned earlier, it can differ from a nameplate rating.
And why does it differ from a nameplate rating?
Certain generation technologies are not available all times of the year. So intermittent resources like renewables have a lower accredited capacity value to reflect that the wind doesn't blow all the time or the sun doesn't always shine. There's also an accreditation methodology assigned to battery resources in the Southwest Power Pool. This Q&A is specifically referencing accredited capacity for a battery energy storage system.
Okay. And so in general, bear with me. Accredited capacity is lower than nameplate, correct?
It can be, again, depending on the accreditation methodology utilized by a reliability entity.
Could it be higher?
It could be equal, or it could be
Equal,
at
but
a,
not,
like it's usually a percentage, 100% or some number less than 100%. It's really, that calculates to a megawatt rating, but the accreditation is usually a percentage based on technologies, or 100% if the resource receives 100% accreditation.
but you could never have an accreditation rating that was higher than a nameplate rating.
No, I don't believe so, Your Honor.
Okay. Go ahead, Ms. Hang.
Thank you. I am going to go to page 55. Let's see. Okay. Okay, so Ms. Tremmel and on page, yes, page 13 of your direct, which I am assuming is what is the paper number of it? Hold on, bear with me. Okay. When you discuss off-system sales margin in your direct, this is the place where we were previously at when you cite to final order in 1744. That final order, the stipulation, and I'm just trying to confirm this and gathering my thoughts. You said earlier, and correct me if I'm wrong, that if the minimum guaranteed number of the net capacity falls below a certain number, SPS is credited to the fuel expenses. You agreed with me, I recall.
Generally, there's first, it's an annual net capacity factor evaluation, and there's, I believe, periods in which the evaluation or cost test applies.
How does so wait, say that again? I'm sorry, I it's too technical, and I'm just a humble lawyer, and say that again because I need to write that down.
Yeah, your question seemed to imply to me that it was like an instantaneous credit, but there's a lot of process to the evaluation, and I was clarifying at first it's an annual average net capacity factor.
What is that?
Can you clarify the question?
Yes, what is an annual average net capacity factor?
I believe when CCN established the average annual net capacity factor for Hale and Sagamore is 48%.
Oh, sorry, I didn't mean the number. I mean, how would one go about finding what the net capacity factor is?
SPS calculates the net capacity factor and reports on that annually in the NCF reports that were also a component of that stipulation, the WIN-CCN stipulation. Those reports could be referenced for the calculation.
Okay, do you not remember the calculation or you don't know it?
As I sit here today, I'm not very familiar with the details of those calculations for the reports.
But I'm not asking specifically about SPS reports. I'm asking in arithmetic terms, like, is it 1 + 1? Is it something multiplied by something -1? Like, what is it?
Objection, Your Honor.
And your objection is?
Back on relevance and scope, Your Honor, particularly, I can't tell which of the two pages we've been directed to out of 13 and 55, but either way, I think it's been 55.
I think she meant 55, line 13. She said page 13, but I've been looking at 55, page 55, line 13.
And Your Honor, that has nothing to do with net capacity factor calculations or capacity factor for that matter.
Yeah, but you let her answer them. You didn't object to it. So your objection now is
May I?
relevancy, but
may I respond?
you wanna comment on the objection before I rule, Ms. Hang?
Yes, she mentioned it several times, and so I'm just asking to define it or clarify what is it?
Okay, and she answered you she doesn't know, so I'm gonna grant the objection because it was asked and answered.
Thank you.
You want to move on?
Yes. In 1744, isn't it true that the SPS's expert in that case, David DeLuca, calculated the net capacity using nameplate capacity?
Objection, Your Honor.
Mr. Du Bois?
Relevance, scope, and foundation. But I can let me know if I should be elaborating when I state the bases or not, please.
Yes.
In terms of foundation, we just got a question about a witness in another case, and the testimony of a witness in a 8-year-old apparently case. I don't think we have a foundation on that testimony or the material in the docket of that proceeding. I don't see relevance or have heard relevance that's been established, and it is certainly not in the scope of Ms. Trammell's testimony what people said in that docket.
Ms. Hang, you want to respond?
I will move on.
Thank you. Go ahead.
Ms. Trammell, earlier on when hearing examiner Hurst asked you if you were familiar with New Mexico PRC case number 1744, you said generally, correct?
In response to hearing examiner Hurst's questions, I said I was generally familiar with the order.
Yes. Now I would like to direct you to what has been labeled Staff's Exhibit PB 3.1.
Okay.
Are you familiar with this?
This appears to be testimony from case number 17-00044. This is not my testimony. This is Mr. DeLuca's testimony.
Yes, but are you familiar with this testimony?
I'm aware that he was a witness in that proceeding.
And are you aware of the proceeding?
Objection,
Yes.
Your Honor.
I haven't heard her answer the question. Ms. Trammell, are you familiar with the testimony or not?
I'm familiar that Mr. DeLuca was a witness. I'm not an expert on the information that he testified to, and I'm not familiar with the details of his recommendations.
Okay. All right, Ms. Hang?
So that is a yes, right? You are familiar with the proceeding.
You're on,
That wasn't the question. The question is, are you familiar with his testimony? And she's answered no.
I will move on.
Okay.
Ms. Trammell, I will ask for the record if the monthly filings regarding Hale and Sagamore, that the denominator in calculating max capacity has been changed because of energy loss.
objection, Your Honor.
Mr. Du Bois?
Again, relevance, scope, and foundation. I don't think we have any foundation for the question, but if I'm interpreting it correctly, we're back on the same relevance and scope of the testimony objections been having.
Ms. Hang, where's the reference in Ms. Trammell's testimony for the pending question?
Your Honor, the case that I'm referring to and the matters I'm referring to is regarding the numbers used to make calculations in the CCN in 1744. And Ms. Trammell is now a witness discussing how these resources will flow through the Fppcac.
Okay, your pending question is, Ms. Trammell, I will ask you for the record if the monthly filings regarding Hale and Sagamore, that the denominator in calculating max capacity has changed because of energy loss. And I want to know where in her testimony she talks about monthly filings regarding Hale and Sagamore and their calculation.
If you would bear with me for a sec. Exhibit 3. While Ms. Trammell doesn't discuss this specifically, the credits that are being requested in the new adjustments are directly related to these calculations, and that is why it's relevant. And I brought that up because we are still talking about the capacity factor.
Okay, tell me where the monthly calculations of Hale and Sagamore are in her testimony with regard to the new adjustments.
It is not, and I will move on.
Thank you.
I would like to talk about or ask you, on page 58 of your testimony, you state that SPS is seeking a change in the adjustments because a change in resources, correct?
You said page 58 of my direct?
Yes, let me see if I meant 58 PDF or 58 paper. let's see. Okay, yes, 58, paper 58. It is on. I think. Yes, it's on it's line 17 of page 58. Circumstances merit a changed approach going forward. Do you see that?
I do.
What are those circumstances?
The circumstances are referenced earlier in the answer, particularly the Southwest Power Pool's resource mix is undergoing changes that significantly impact how SPS manages its off-system sales. And then I use a particular example of the battery project.
Okay. And then after the end of line 17, you drop a footnote 28. Do you see that?
Yes.
And could you read that for us, please?
Footnote 28 reads, if a variance from the order in case number 17-00044-UT is deemed to be required, SPS requests such a variance for the reasons stated in my and Mr. Bogner's testimonies, including associated with the changes in circumstances from the time the final order in that proceeding was issued.
Why is it called a variance here?
The sentence at the end of the answer on page 58 is summarizing SPS's request to establish a framework for off-system sales margin sharing for new resources, either because the condition in case number 17-44 was not triggered, or as we read, that circumstances merit a changed approach. So to the extent the commission finds that the off-system sales margin sharing framework that was established for existing resources in case number 17-0044 applies to new resources, which is clearly not the company's position, then SPS would request a variance from that order to establish an off-system sales margin sharing framework for resources that have subsequently been added to our system, and particularly the resources at issue in the CCN case number 23-00252, which were generation technologies that did not exist on SPS's system in the 2016-2017 timeframe when that wind CCN settlement was entered into.
Okay, so in layman's term, new things are happening, so we need a new framework. Is that the gist of your?
Objection.
Yes.
Yes.
Sorry.
Ms. Tremmel, case 1744, the final order, was that not based on the stipulation?
It was. I think there were, through the different final order or different orders, I think there may have been revisions to the stipulation, but yes, generally that was a stipulated result.
Except for the recommendation not to approve retroactive rate making.
So
Never
the answer
mind.
was yes.
Go ahead.
Sorry. Mr. Dubois, did you? No, okay. So it is based on a stipulation. That is a yes, correct?
Objection.
Mr. Dubois?
Asked and answered. We just talked about whether it's based on a stipulation.
And I'm just confirming whether it was a yes because it wasn't not a yes or no answer. I just want to be clear.
to have the record completely clear, Ms. Trammell, would you agree that the final order in the case was based upon the commission's decisions relating to the certification of the stipulation?
Yes, Your Honor.
Go ahead,
Would-
Ms. Hang.
Yes, wouldn't you agree that a suggestion of a variance from an order based upon the stipulation is substantively a unilateral amendment to a stipulation?
Objection?
Based on what? I think she can answer if she knows.
Okay.
Can you repeat the question?
So to ask for a variance from an order that is based upon the stipulation with various parties, isn't that somehow the same, not somehow, isn't that substantively the same as trying to amend the stipulation, but without amending it?
I don't think so. Like I said, this is an or. If the commission finds that that condition
Wait,
is
where?
triggered, the or is in line 16.
Yes, but if it is triggered, then it would be changing the stipulation, wouldn't it?
But that would be the commission's action, not the company's actions.
But are you saying the commission will sua sponte by themselves go ahead and change it without your request?
No, but the commission, in making a determination on SPS's off-system sales margin sharing proposal in this case, will make a determination on the request. So in that determination, they'll either be deciding that case number 17-0044 and the off-system sales margin sharing framework that was established for existing resources in the WINS CCN applies to all future resources, all resources added to SPS's system, or they will not.
So it's your contention that the commission will find reasonable reasons to change their final order, even if it's substantively the same as amending a stipulation with other parties.
Again, SPS's position is that no amendment is needed. That WIN settlement applied to resources at the time, not all future resources that could ever be added to SPS's system in the future.
All right, I will move on. I am going to direct you to page 65, and I think that is a paper 65 of your direct testimony.
Okay.
And it is, in fact, not page, let's see. Oh, sorry. Okay, on paper number, page number 17, you talk about if approved, the following changes would apply. Do you see that on line 9?
I do.
How is that gonna look in terms of customer bills? If you get your wish list, does it change the customer billing?
Yes, there's a number of items listed in this paragraph, both costs and tax credit benefits to customers that SPS is proposing to be reflected.
In terms of, like, how is it gonna be just new line numbers, or how is it gonna show? Like, if I'm an SPS customer and this goes through and I get my bill, like, what would I see different from the previous month before these took place?
So these adjustments affect the fuel factors, the SPS's monthly fuel factors. So the result of this proceeding would reflect items that would either flow through SPS's monthly fuel factors or not. So that's reflected as the fuel costs on customers' bills.
Is that how you're gonna, I mean, like, how do I know that that's the thing? Like, how is it gonna, I guess, let me rephrase this. How is it going to show up on the bill that is sent to the customer?
There's a fuel charge on the bill, and these items, the monthly factors would be adjusted and then reflected in that fuel line item.
Okay. Is it SPS's contention that a normal person, and I'm saying normal in terms of like people who are not part of the public utility community, which is like most people, is it SPS's contention that the customer will understand the change in bill in their bills?
I can't testify to what individual customers will particularly understand, but I think customers understand that tax advantaged resources come with tax credits to their benefit, and SPS's requests, and consistent with the notice that we issued in this case, that we're proposing to flow through the value of those tax credits to customers.
So that's a yes, it is SPS's contention that, for example, my father would understand what is on the bill.
Objection, Your Honor.
Mr. DuBois?
Asking a witness what another person thinks, I think is, there may be a different way to ask a question related to this, but I don't think Ms. Trammell is an expert on what the named individual might think.
Ms. Hain, you want to rephrase your question?
Yes, what steps if any, is SPS planning to take to communicate the changes to a customer's bill should the wish list go through?
I don't think there's any customer communications directly. Again, these items are reflected in our monthly fuel reports.
You've lost me. Say that again. I guess, wait, I'm sorry, say that again.
I understood that you asked what customer communications we would have to reflect changes as a result of this proceeding. Largely, SPS's tax credit proposals in this proceeding are very similar to the mechanics of how tax credits for Hale and Sagamore are treated as a credit or an offset to eligible fuel expense. So we would be adding more value to that flow through relationship through the fuel factors to customers. So there's not a direct customer communication that the company has planned. The value of tax credits flowed through to customers is reflected in our monthly fuel reports, both for Hale and Sagamore currently, and as proposed, and if approved, the addition of the value of PTCs from the solar facilities.
So in short, nothing, right?
No direct customer communications, no.
Okay, thank you. Let's see. And that concludes my cross. Thank you so much for your time. I appreciate it.
Thank you, Ms. Hain. Mr. Trammell, we've got a few questions for you. And I'm going to start with SPS Exhibit 3, your direct testimony.
Okay.
Are you familiar with the testimonies of the other witnesses in this case?
I've reviewed them, but it's been a few weeks.
If I were to characterize NMDOJ witness Reno's testimony, as setting forth what I would characterize potentially as an unfavorable outcome of proposed legislation, would you agree that she testifies to that particular subject?
I recall references to federal legislation that's been passed and maybe an opinion that it could be repealed or otherwise changed in the future.
That's it. Oh, do you agree with what witness Reno has indicated, that if there is this particular change in legislation, that might negatively reflect on your new proposed resources?
I would agree that if production tax credits for solar or some of the transferability provisions of the Inflation Reduction Act are changed, that could have an economic impact on SPS's proposals and the resources.
Well, if the production tax credits and investment tax credits went away or were significantly altered in legislation that was effective, is SPS going to go ahead with those projects?
Yes, the projects were approved based on the need for their capacity and energy contributions to the SPS system in order to serve customers in a particular time frame. The need for those resources has not changed.
Well, wasn't the proposal in the CCN cases on those new resources and wasn't part of the SPS's proposal and the justification for approving those had a lot to do with what tax credits were going to be available, wasn't it?
The overall cost of the projects played into the project selection in the RFP, but again, this RFP was issued to solve for a capacity and energy need through like in years 2026 and 27. So, that's next year, and these projects are under construction.
If the tax credits go away, aren't the ratepayers going to end up paying more because of the non-availability of the tax credits?
The tax credits going away wouldn't change the invested capital costs of the projects, but it would affect SPS's ability to flow through the value of tax credits through the fuel factors, which is an offset to eligible fuel expense. So from an overall bill perspective, yes, customers hypothetically would incur more costs because you wouldn't have the PTC value offset in the fuel clause. But the cost of the project, the invested capital of the project would be unchanged.
Right. I mean, SPS is going to get paid one way or the other, right? It's just, if the tax credits go away, it's your ratepayers that are going to pay more for these projects than originally proposed in the CCN case, right?
Correct.
Beginning on page 11 and subsequently in your testimony, you're discussing the issue of off-system sales. Margin sharing, correct?
Yes, Your Honor.
And a lot of that justification has to do with what happens in the SPP, correct?
Yes, and I would say generally also the resource additions added to SPS's system.
And I'm just wondering how much latitude, if any, does SPS have in its relationship in the SPP to avoid, for example, to avoid curtailment?
Mr. Bogner can speak in more specificity to the market operations, but generally, Your Honor, we have a lot of discretion in how we operate our units and how we make them available for market operations, consistent with the resource bids that are submitted into the SPP. So as a load serving entity, we are required to have sufficient generating resources to cover our load plus a planning reserve margin requirement. So there's discretion is on the company there to how it operates its units to ensure availability. Ultimately, the dispatch of the market is directed by the SPP, but resource availability is the responsibility of the load serving entities like SPS.
And I'm familiar with your testimony and Mr. Bogner's testimony, where you refer to above and beyond. Is that correct?
I believe I used that term to describe the operational characteristics that Mr. Bogner testifies to. Yes.
Operational characteristics of what SPS does in managing its performance in the SPP, or facilitating off-system sales, or Something else?
Managing our resources to go above and beyond to ensure their availability for opportunity sales or gen book sales, as we refer to them, which are the off-system sales, the sales into the marketplace after our native load has been served.
Because I kept asking myself, well, why should there be an incentive for doing your job?
Well, the responsibility is to serve native load, right? So the job is to make sure resources are committed and available to serve the load on an individual load serving entity system. So SPS is retail and for a little bit longer, some production wholesale customers that we have. But SPS does not have an obligation to make units or ensure units are available for sales beyond that into the marketplace that are not serving obligation load. They're serving other entities in the market and are opportunity sales in the sense that SPS has an opportunity to earn a margin on those sales for the benefit of customers. And the margin sharing proposal is the incentive to incentivize SPS to, again, ensure those resources are operating well, are available, and can be called upon for those off-system sales margin type sales. Again, those are after obligation load has been served.
Right, and I guess I would just, I paused too long in my question, and I didn't get the rest of the question out.
My apologies,
Or
Your Honor.
you answered. But, I mean, obviously you have more obligations with regard to your ratepayers than the one that you elaborated. I mean, as part of the regulatory compact, you have to provide safe and reliable service, right?
Yes.
And you, as part of the regulatory compact, you have the opportunity to earn a return, but you have to provide your service at just and reasonable rates, right?
Yes.
Okay, so there's other things that SPS has to do, and I understand that the SPS position is, yeah, but we don't have to offer this excess power. But couldn't the counter to that be, well, have you got excess capacity then that you shouldn't be earning a return on?
Again, some of these sales are energy sales into the market. So a capacity position, we may not be in an excess capacity position and still be able to make an off-system sale, right? We're talking about dispatch in a real-time energy market. So we're talking about energy sales and ancillary services into the integrated marketplace. These aren't bilateral capacity sales that would illustrate a long position from a capacity standpoint.
So basically timing.
Real time in real-time markets. And I would add, Your Honor, additional generation for off-system sales means additional use of the facilities, right? Additional runtime. And so there's a balance there in protecting customers and making sure that the right balance is struck between running units for off-system sales, which do produce a margin, right? And that margin is shared, or not running a unit or not making an off-system sale because of limitations on a generator or other costs. And so there's, as Mr. Bogner testifies to, a number of factors that go into those offer prices to make sure that units aren't being run more than they should, or outage schedules aren't being sacrificed in different things, right? That's what we mean when we talk about availability, that balance of not incurring more costs for those margins unnecessarily.
Also in your testimony, and you're just referencing the summary on page 12, but you're talking about TOU or time of use potential pricing options, right?
Oh, yes. This was as you mentioned, a summary, and in my direct testimony, we provided an update to the commission on the time of use stakeholder process that was still ongoing at the time this testimony was filed.
Yes, you did. And I understand that it's ongoing, and I understand the steps that have been taken. And I understand the testimony with regard to why both technically and policy wise regarding potential impacts to who might pay. But does SPS have a general idea of when this time of use change or information would be presented to the commission?
The stipulation in SPS's last rate case, case 22-286, which was the provision that provided for the time use stakeholder effort, that the result from that process is basically information that SPS will provide in its next rate case. So that was a provision and framework of the agreement in the 2022 rate case. I specify that case, Your Honor, because that differs some to the stipulation in this proceeding, this fuel continuation proceeding with regard to the time of use pilot only for LGST customers. So there's kind of two things that would be happening there with respect to time of use process. The stakeholder information that would be provided in our next rate case, as well as now pursuant to the stipulation filed in this proceeding, a proposal to form a time of use pilot for LGST customers. Again, just a proposal. The stipulation reflects that that would need to be a request authorized by the commission in our next rate case.
So you're actually going to include, pursuant to the stipulation, a pilot proposal in your next rate case, right?
For particular customers, yes, that's the
Right.
stipulated agreement.
And that race case is going to be filed when?
It's anticipated to be filed later this year.
Like next week?
Q4, likely.
And is it going to be a future test year case?
We are evaluating filing a future test year. Again, as SPS has described, the primary driver of the timing of our rate cases are generation additions to our system. So to the extent that the commission does not approve the self-build solar facilities through the RPS rider, that would be a key driver of a revenue requirement deficiency in base rates that would be reflected in a future test year case filed later this year.
Okay, that went. I thought they already approved the self-build.
They approved the resources. SPS requested rate-making determinations in the CCN, as you're well aware. Some of those are now in this proceeding because they were not approved in the CCN. Right. So the cost recovery of the revenue requirement is currently at issue in SPS's RPS proceeding.
And will you elaborate for the record why that there's a difference in the renewable costs in this proceeding as opposed to the renewable costs that would go through the rider?
Do you mean the RPS rider?
Yes.
The RPS rider would recover the revenue requirement of the solar facilities. In this fuel proceeding, there are components related to the solar projects, but not the revenue requirement. So we're proposing to pass through or flow through the fuel factors, the value of the production tax credits associated with the solar projects following the commencement of cost recovery. We're proposing to recover transaction costs associated with transferability of unused solar tax credits if SPS is able to utilize the provisions of the Inflation Reduction Act and sell those unused tax credits to third parties. And if we're unable to transfer, sell those unused PTCs to a third party, SPS requests to accrue a deferred tax asset and recover a return on that asset through the fuel factors. Those were our, with respect to the solar facilities, our original requests in this proceeding. So those fuel related items are unrelated to the revenue requirement, but they are related to the projects. Of course, the position has changed slightly pursuant to the stipulation filed with regard to items that would go through the factors versus base rates specific to the solar projects. So in the stipulation, we're still proposing to flow the value of the PTC credits as generated through the fuel factors after cost recovery commences. So that is unchanged from our direct case. The stipulation just memorializes SPS's retention of 100% of the PTC value before recovery begins. But, and also unchanged is the recovery of the transaction costs associated with sales of unused PTCs through the fuel factors. Those are to be netted against the PTCs, which under the stipulation are still flowing through the fuel factors, capped at the 10%, consistent with SPS's direct case. What has changed with respect to the solar projects is where the recovery of a DTA, if one exists, would occur. That's moved from the fuel factor in SPS's direct case to base rates under the stipulation. I would also add the stipulation limits the time period in which the PTC retention would be had by SPS.
So then basically, for clarity of the record, in addition to revenue requirement on the resources coming from, potentially coming from the renewable rider, certain energy costs and other items, fuel, coming from no, I want to say fuel costs coming and potentially something related coming through the FPPCAC. SPS will also be collecting on these new renewable resources in base rates, correct?
Pursuant to the stipulation, the item that would be recovered in base rates would be the DTA. So a portion of the costs associated with the solar facilities.
And that's it?
Assuming the commission approves RPS recovery of the revenue requirement, yes, in base rates. Again, the PTC value would still flow through the factors. Transaction costs would flow through the FPPCAC as a net to the flow through value of the PTCs.
Are you asking for a return in the renewable case?
A return on the DTA?
No, a return on the,
Revenue requirement?
yeah,
Yes.
of what?
SPS's weighted average cost of capital.
I just, for clarification purposes, on page 13 of your direct testimony, you refer to at line 14, 19 megawatts of diesel fired capacity.
Yes.
That's actual diesel?
Yes, that's our Coy County facility in Tucumcari.
Okay. I just don't see any reference to, like, I guess, any type of dual fuel that utilizes your fuel oil.
Here on page 13.
Yeah.
Correct. Yes, you're correct. Some of our facilities are capable of burning dual fuel. I believe probably Mr. Romer or Mr. Rosman would have more information on those dual fuel capabilities, or perhaps Mr. Bogner. I don't recall which units have which capacity.
Okay, I guess I was just wondering if the fuel, if the fuel oil was encapsulated in one of these other types of generation resources.
I see. No, those megawatts are not included in the other either coal-fired or natural gas-fired capacities mentioned in that sentence.
Okay. You say on page 14 of your direct testimony that SPS has been using a monthly FPPCAC of some type, I guess, since February of 2002, correct?
Yes.
Do you have a similar mechanism in your other jurisdiction?
There is a fuel clause in Texas and a fuel cost adjustment in our FERC jurisdiction. In Texas, the implementation of the fuel factors is slightly different than New Mexico's implementation, but yes, a fuel clause exists in both states.
Implementation meaning?
The fuel clauses in New Mexico adjust on a monthly basis. The timing of adjustments in Texas follows a slightly different process. There's a longer period in between factor adjustments, whereas in New Mexico, it adjusts monthly.
It adjusts monthly, but is it still like on a 2-month lag from when it was actually used?
The true up that flows through the monthly adjustments, yes. So there's a forecast, actuals, and then true up component to the monthly adjustment.
Okay. You testified on page 15 of your testimony about whether or not the commission has authorized any rate-making treatment of any items through the FPPCAC since SPS's last FPPCAC continuation was filed. And you answer at line 15, yes, that in the last base rate case, 22000286, the commission authorized recovery of nitrogen oxides, or capital N, capital O, little x, allowances through SPS's FPPCAC, correct?
Yes.
And then you go on to say in case 23-00384, the commission authorized the recovery of variable O&M associated with the newly approved 15-year PPA with Borger Energy Associates, which you refer to as a new Borger PPA through SPS's FPPCAC. Correct?
Borger, yes.
Borger. Okay. So in trying to establish in my mind the potential change in treatment, SPS is requesting for the sharing of the off-system sales margins. SPS is it would potentially apply to not only these new renewable generation assets, but would also apply to this new Borger PPA. Is that correct?
I'm trying to recall my testimony. We stepped through both this facility and Harrington. So Borger would be unchanged, and the off-system sales margin framework, because that, while it's a new PPA, it's the same facility, and that facility was on SPS's system at the time of the wind settlements. So that's considered to be an existing facility on the system. Whereas Harrington had a gas conversion that was approved in a CCN subsequent to the effective data rates in that 17 rate case. So the Harrington gas conversion under SPS's proposal is a new resource with the CCN approved after the effective data rates in 17, I think it was 355. But the Borger facility would not be included in a different off-system sales margin sharing framework.
Okay. Then you go on page 16 and you're talking about the revenue and expense statements that Mr. Malley was responsible for, right?
Yes.
And has SPS provided any updates? So my reading of your testimony is that reports and things only go through June of 2024, and I just wondered if SPS has updated those through the end of the year.
I don't believe we have.
Why not?
That's probably a better question for Mr. Malley.
Consider that a bench request, Mr. Dubois. I don't think that they necessarily have to be updated through now, but I think they should be updated at least through the end of the year, since we look at those particular numbers.
Understood, Your Honor. Thank you.
Okay. Okay, then in your testimony on page 20, you get to the heart of the matter. The request to continue the FPPCAC, which is, I consider, the foundation of our house, and that they're done every 4 years. And I just want a clarification from you, Ms. Trammell, about exactly what it is and when the time the company is requesting from the commission. So if you look at page 21 of your testimony, the question posed at line 5, for what period of time is SPS requesting to continue the use of its FPPCAC? And, I already know that in your testimony, you talk about how it was filed 2 months early, because you're going to have a lot of rate filings this year, right?
Yes.
Okay, so you say, we know it's 4 years. So in your testimony, you say at line 8, in my testimony, I refer to the period of time from any commission authorization in this proceeding through the date that either A, SPS's authorized use of its FPPCAC expires, or B, the commission grants a subsequent authorization for SPS to continue further the use of its SPPCAC as the continuation period. I don't really know what it is you want there, Ms. Trammell. I'm not familiar with an FPPCAC expiring. Can you tell me where you got that?
The purpose of this sentence is try to define the continuation period, which is also the nature of your question. So we were saying that the continuation period would start with commission authorization to continue the factors in this proceeding and go through those periods. So presumably, if we were in B, that would be through a commission decision in SPS's next continuation filing, which, while there is discretion when those can be filed, generally, as you noted, they're filed every 4 years. So absent the commission making a determination in this proceeding that for some reason the factors should be in effect, say, for 3 years and then expire, SPS would expect to continue the factors and then seek a subsequent authorization for continuation in our next continuation filing, which will have to be filed in 4 years from the date of an order in this proceeding.
Oh, too confusing for me. So
I was trying to capture that I don't know
I'm just
exactly
going to
what
go with the rule. Okay. So that no, I understand what you were trying to do. It just it's getting lost, and so I think if in any proposed findings or conclusions, you might just say, and we want it to go from 4 years from the commission order date.
Yes, Your Honor.
That might be better, or
and
not.
with no party opposing the continuation of our factors, I think we can definitely be more clear on that.
Yeah, I wanted some clarification, and we're almost at the luncheon hour, but you say and this is to help me put in perspective what was requested initially. You say on page 28, you're responding to the question posed on page 27 at line 3. Why is SPS bringing the request you described in this proceeding? And beginning on line 1, in the middle of the sentence, you say, an FPPCAC continuation proceeding is necessarily a category of rate-making proceeding with considerations distinct from base rate cases.
I'm sorry, which line are you on? I'm sure you're reading
Line
it.
1.
Oh, you're on 28. Got it.
Uh-huh. So I guess I just wanted to find out how a fuel clause case, which is, we're primarily here to determine whether or not the requirements of the statute for passing through fuel, rather than putting it in a base rate case. How is it that you think that determination of that one subset of issues is the same as all of the myriad of issues and related issues that are included in a base rate case?
I don't think they're the same. But I do think the fuel continuation proceeding is a rate-making proceeding to the extent it's considering and deciding rate-making items to flow through fuel. That is different than a base rate case, but coming out of the CCN, the commission and the recommended decision in that proceeding referred to rate-making treatment recommendations, and the commission directed those matters to be resolved in other rate-making proceedings. So this sentence is my testimony establishing that a fuel continuation proceeding, to the extent it's considering and deciding matters that would flow through fuel, those are rate-making determinations. So this is a rate-making proceeding. But I do think the scope of a continuation proceeding, and certainly the scope of SPS's requests, rate-making requests in this proceeding, are very distinct from a base rate case.
And just so that I have clarification on this issue, the last sentence on that page says, SPS's sales of unused tax credits will also vary and therefore also are appropriately handled via the Fppcac. That's your testimony, correct?
Yes, particularly with the solar facilities, the tax credits are as generated, so they're going to vary monthly based on the production of the solar facilities. Their PTCs are eligible on those resources for the first 10 years of operation. Any sales of unused tax credits will also vary in volume in direct relation to the production output of the solar.
Are there any tax credits currently being utilized through the Fppcac?
SPS is currently flowing through the value of the Hale and Sagamore production tax credits as generated through the fuel factors. Transferability provisions that are requested in this proceeding associated with the solar are not applicable to Hale and Sagamore. So what you don't see currently in SPS's fuel factors are transaction costs netted against those flow through PTCs. And pursuant to the wind settlement, the DTA is not recovered. The DTA associated with the Hale and Sagamore wind facilities is not recovered in the factors. So little distinction there, but yes, the PTCs from the wind facilities are flowed through to customers through the fuel factors. Unused tax credits for the solar facilities we are proposing, well, we've talked about the proposals on those, but that's different than Hale and Sagamore because the Inflation Reduction Act was not in place at the time the wind facilities were proposed or approved or constructed.
And when you say handled via the FPPCAC, are these production tax credits accounted for on a monthly basis or a biannual basis or an annual basis?
So this sentence is specific to the unused tax credits. So these are tax credits that SPS as an entity has earned and due to its tax position has been unable to utilize or monetize. With transferability provisions of the IRA, we can sell them so they can be monetized through the sale to a third party. We're proposing that the transaction costs there be netted in the factors. The benefit to customers of transferability is as the unused tax credits are sold, it lowers the DTA balance that would accrue in rates and earn a
Right.
return.
But specifically, I'm asking for your current, the way that you currently do this.
The sales?
Are those, yeah, the PTCs for Hale and Sagamore, are they accounted for on a monthly basis or an annual basis in the FPPCAC?
The PTC flow through is on a monthly basis in the FPPCAC, and that's a particular line item in our 550 reports.
You know what line it is?
I can look at my attachment to my supplemental testimony and tell you. 1 second. That was too far. It is attachment BATS2 to my supplemental testimony, page 1 of 2. This attachment is an illustrative example of what the fuel reports could look like with SPS's proposals, but you can see on page 1, hopefully without having to utilize your magnifying glass, the Hale and Sagamore PTC, the value of that PTC is being flowed through to customers on line K in the other adjustments / Rule 550 variance section. In this illustrative example, it's a value of 6.4 million.
So there's a $6.4 million basically production tax credit in 1 month.
Again, this was an illustrative example.
Well, how grounded in reality is it?
We could look at one of Mr. Malley's fuel reports, but I don't know that number off the top of my head.
Okay. Well, maybe I'll save that one for him then. But as you indicate, also, so those are the ones that SPS can use, right? The tax credits.
This is the value of a tax credit. So
value.
I think there's an important difference there, Your Honor, because SPS as a taxpayer receives a tax credit, right? A PTC as they're generated from these facilities. We don't pass a tax credit back to customers, right? That would be the wrong implication for a taxpayer. What the customer needs is the value of that tax credit. So we are providing the value of that tax credit that SPS as a taxpayer is receiving as they're generated from the production of the solar facilities. So we provide that benefit to customers before we realize the benefit of being able to utilize or monetize that tax credit against our tax liability. That's the flow-through value of the PTC. You know, it's not like it's cash, right, or something that SPS is receiving that then passes to customers. It's a value of a tax credit.
And that's sort of the yin and the yang of this, right? I mean, they're getting the flow-through value, but on the other hand, if SPS cannot utilize those tax credits, then they become a deferred. what, deferred tax asset, and
Yep.
you're earning a carrying charge on them, right?
With respect to that relationship generally, yes, if we're unable to transfer them, then the balance in the DTA would grow. Transferring the unused tax credits lowers or eliminates the DTA balance to the benefit of customers. Transferability began in calendar year 2023. So production beginning that calendar year, any tax credits associated with production in that year can be transferred. But I would just note that the Hale and Sagamore stipulation has particular parameters around the recovery of the DTA associated with those facilities, and that is limited.
Well, my bottom line here is what I'm trying to figure out is just in trying to understand this, if these tax credits are supposed to be so great, if you can't actually sell them or transfer them and they just sit as an asset that SPS, because of their tax structure, isn't ever going to use, then how can I evaluate that as a, as a big positive?
So prior to the passage of the Inflation Reduction Act, the model DTA was evaluated in the overall project costs of these facilities because that timing nature of federal tax policy applied. I think the inverse of your question illustrates the customer value of transferability provisions in the Inflation Reduction Act. The ability to transfer is a cash flow benefit to the company, but a real value to customers in reducing that DTA balance.
I mean, do you think that the Hale and Sagamore DTAs are ever going to be eliminated?
I don't know that any DTA associated with the periods prior to the effectiveness of transferability. Again, it was started in 2023. So Hale and Sagamore went into service earlier than that. But we see a very sizable market interest from third parties to purchase unused tax credits from entities like electric utilities. So we are confident in the corporation's ability to sell unused tax credits from any source, whether it's Hale and Sagamore, the solar facilities, or the battery project.
Yeah, and I think somewhere I actually circled confident and wanted to know what the basis of your confidence was.
My confidence comes from our demonstrated ability to sell all the tax credits thus far. Xcel Energy has negotiated agreements with third parties to transfer these unused credits, and we've been successful in doing that for customers in all of our jurisdictions.
Okay. I mean, I'm just wondering, I mean, could it end up like REX? Capital R, capital E, capital C, renewable energy certificates, where it seems like people had great ideas that, that these RECs were going to be fungible and, they're going to be able to sell them and whatever. And then it ended up that, no, that wasn't the case when the law changed. And it seems like, companies got stuck, including SPS, with a lot of RECs.
Your Honor, I think
Didn't they?
I don't claim to be a tax expert, but what I do see as potentially differentiating factor between RECs is the ability of third parties to use the unused tax credit that an entity like SPS would be selling in a much broader scope, right? So if somebody wanted a REC, they had a particular interest in a renewable energy credit. Here, there's potentially a wider range of reasons why a third-party corporate entity may want to be offsetting their tax liability, and the magnitude of their tax liability can be influenced by a number of factors. So I think the appetite is significantly greater as unused tax credits from electric utilities can be sold to unaffiliated third parties in any economic sector.
Okay. Oh, okay. And my reference to the getting the clarification from about the resources comes from your testimony on page 30.
I'm sorry, I didn't hear
We've
the
already
page
talked
number.
about that.
Okay.
31. When you were telling me which generation facilities potentially could benefit from this new sharing. Can you briefly tell me your testimony on page 36? And the heading is why SPS has satisfied the requirements in 6287E 1 through 4 NMSA. And on page 36, you say, and this is recovery of fuel and purchase power costs through the Fppcac at line 12 will avoid putting SPS at a competitive disadvantage versus other utilities and cooperatives. Why? Because they have Fppcacs or why?
Yes, removing a fuel clause for SPS that's been in place for over 20 years would be a very material change to our revenue recovery framework and can put SPS at a competitive disadvantage against other utilities that haven't received such a change, whether that's New Mexico utilities or other utilities, say that SPS competes for capital financing with.
Okay. Mr. Dubois, well, I'll ask your witness. Ms. Travel, on page 38, you indicate at line 9, SPS's fuel and purchase power costs represent approximately 22.7% of the retail customer's total bill during calendar 2023. Do you have an update for 2024 on that number?
We can certainly provide one, Your Honor.
Okay. Please consider that bench request 2.
Understood, Your Honor.
Okay, and then you have an impressive list beginning on page 24 of all the prior cases that potentially affect the Fppcac.
You said 24?
And 42.
I'm sorry. My husband's dyslexic, but apparently I am too.
Are any of these going to drop off anytime soon?
I'm just reviewing the list. I don't recall the terms of some of these PPAs. SPS's wholesale sales, as you know, have been declining on a scheduled ramp down, with SPS's last wholesale customers leaving the system in 2026.
Are those primarily the co-ops in Texas?
New Mexico.
Oh, in New Mexico.
So item 3 in that list would
potentially
be shorter. These other ones are
really specific.
yeah, and more of like an implementation matter as opposed to a particular item.
Okay. And this is a question I was going to ask. Page 61 of your direct testimony. And you're answering the question posed at page 60, line 15. Is SPS able to identify any off-system sales that would not have occurred but for a 10% margin sharing on its tax system or predating the 100% sharing in New Mexico? And so you talk about that, and then on the next page you say a particularly notable recent result of the systemic approach is that SPS successfully disputed resettlement variances and recovered $4.5 million associated with the Winter Storm Uri transactions by performing its own critical reviews of SPP marketplace transactions. That's your testimony?
Yes.
Your prior Fppcac case that doesn't want to come up. (19-00315). Nope. There it is. There was a request there was an emergency request from SPS for a variance to implement its Fppcac and implement a deferral and surcharge mechanism in response to the winter cold weather event, which was partially granted. Is that related in any way to what you're referring to in this paragraph?
To the extent which you referenced was related to Winter Storm Uri, it would be associated with the same weather event. These, in my testimony, I'm referring to SPP settlements and resettlements. So our auditing and review of SPP settlements in the market, we thought we saw areas for correction and pursued those, which ultimately resulted in more market revenue to SPS.
Okay, I know in the order the commission granted in response to your request, it refers to a suspension of an adjustment of the factor for March of that year and was going to remain until effect until the new factor, surcharge amount and mechanism and or true up of the SPP pool settlement is approved by the commission.
I'll have to review that case, Your Honor. I don't know the details right now.
Okay, talk to Mr. Du Bois. He filed it. He filed it in 19-00315 and in case number 21-00046 UT, which was apparently your request for suspension and establishment of a regulatory asset and approval of the surcharge. Again, just trying to figure out are these two things related to, number one, the paperwork you're filing in this case for the FPPCAC, and then number two, your testimony claiming victory with $4.5 million, which I put in the above and beyond category, or I think that SPS would, or is it something else? Okay. Yeah. and where I circled confident, that's on page 63. Line 6. Question posed at line 1, will using the SPS battery project and Wildcat BESS to make off-system sales impact customer reliability? And you answered no. And then on line 6, you say SPS is confident that it can find opportunities for energy arbitrage that will benefit customers and protect its ability to provide uninterrupted, reliable service to its retail customers. And I think you answered that question. Then I've already asked you about TOUs. And you already answered about the RPS. I did have a question about the additional request on page 72 and the collection of costs for procured energy to charge the battery facilities. Okay.
Okay, I'm here.
You see where I am? Okay.
Yes, Your Honor.
So my question is this: is that an approval for whether? So you're saying procured energy? Was that include your own generation? To, if you're solar, if SPS solar or wind is going to charge that battery, is that considered procured, or is that just from a PPA?
No, that wouldn't be considered procured because these are not paired resources. So this isn't a solar plus storage facility. These are standalone.
Oh, they're not. Oh, I thought, okay. Sorry,
No,
I thought that some of those solars were going to be with the battery.
they're
No?
all individual projects. So while they're located, the Cunningham 1 battery project is located at SPS's Cunningham facility. There's also a proposed and approved solar project going in at Cunningham, as you know, two, actually, one in 26, one in 27. They're not paired resources. And so the battery project, Cunningham 1 BESS, will be charged by, we say, the system, not direct charge by a paired solar facility nearby. Now, an electron is going to flow right to the path of least resistance and doesn't know its source, but technically the energy cost to charge the Cunningham 1 battery would be coming from the system. That could be a mix of company-owned resources, or it'd be from the market, but it's going to settle from the market charging. SPS is also responsible for charging the Wildcat battery, And that is also not a paired facility. So while it's located at the site of an existing wind facility, it's not paired with that generation. So it would also charge from the market.
Do you have any paired?
Not on SPS's system.
Are you planning on having any paired?
We expect that solar plus storage or wind plus storage facilities could be proposed in competitive solicitations. SPS's current IRP, we're in the process of bid evaluation. So there could be some paired projects selected in the future for SPS.
Okay. All right, I think that's enough on the direct, and I think probably people are gnawing on their pens, or people probably don't use pencils anymore. What's 12:35? Let's come back at 1:35. We'll take an hour recess for luncheon. I've got a few more questions for you, Ms. Trammell. We'll allow Mr. Du Bois to do any redirect he wants, and then we'll allow Ms. Hang to ask questions based on the redirect or my questions, and then we'll move on to our next witness. Very well. Enjoy your luncheon. We're recessing. Let me just remind you again, we have the YouTube. It's going to stay on. So we need to act accordingly. Thank you very much.
Thank you.
How we doing, Ellison?
Ready when you are, Madam Hearing Examiner.
Try again.
I'm ready when you are, Madam Hearing Examiner.
Okay, great.
All
Thank
right.
you. I always have to remember to flip those headphone button.
Ah, there you go.
Let me know if I'm like hacking into the microphone.
You are not.
Great. I guess after you live someplace 30 years, you become allergic to whatever lives there. I don't know. I should have had more sympathy for people with allergies because I think I have them now. Okay, if we're ready, let's go back on our record. We have returned from our luncheon recess and are ready to resume a few questions with Ms. Trammell. Just remind people we are live streaming on YouTube. Okay. I think we pretty much covered in my questions on your direct the majority of the topics that I wanted to know, Ms. Trammell, from your supplemental and I mean, for the most part, I think I understand your stipulation testimony. Of course, looking at okay, why are you not giving me the screen? To do that. Okay, well, no, well, it might pull up from there. Nope. Okay, I don't know. Okay, can we see the comprehensive non-unanimous stipulation?
Yes, Your Honor.
Okay. Okay. Ms. Trammell. Section 1.1 of the non-unanimous stipulation refers to the agreement that all of the signatories find that the application, including, I guess, the supporting testimony, found that the requirements for continuation of the FPP CAC have been met. Is that correct?
Yes.
And it's also my understanding in reviewing staff witness Mr. Rossi's testimony in opposition to the comprehensive non-unanimous stipulation. He does not object to that part of the stipulation, does he?
That's my understanding.
Therefore, if I took the finding and conclusion number 20 from the commission's order granting variance and appointing hearing examiner, that the commission does not take a position about whether including in the merits of the application anything, whether the FPP CAC is the proper vehicle to effectuate proposed credits and costs. And I said, no, it's not. Then we'd be done, right? Because everybody's in agreement that the filings on the FPP CAC should be granted, right?
We would be done with respect to continuation of the factors, yes. The other components may still need a commission determination, even if they're decided differently than what the stipulation lays out, because those frameworks, if a decision is not made in this case, would default back to normal course of business. And I think the commission is saying in their order that before they determine the merits, they wanted to see that record. But Your Honor, if you make those determinations that these things should not be approved or the mechanics and framework should not be established, the continuation would be finished and those normal course of business actions would be what SPS would operate under exiting this proceeding.
So is it fair for me to characterize the comprehensive non-unanimous stipulation as one where, like I say, we've already looked at 1.1 that has to do with the FPPCAC, and then basically 1.2 A and B, 1.3, 1.5. Well, no, not 1.5. Those sections all have to do with PTCs and ITCs, right?
That's correct.
And section 4 is the off-system sales, right?
1.4, yes.
Oh, I guess I should need to scroll. Here we go. 5 allows the collection through the FPPCAC of energy-related costs to BESS projects, right?
Correct.
That wasn't something that was determined in the CCN.
It could have been, but no, it was not.
Okay. I did a P&M combined project a couple of years ago. Makes me want to go back and look to see what we did now. I'm going to have to do that tonight. Is that something that wasn't included in the statute?
This really originates because of the level of detail in the commission's fuel rules and the FERC accounts that are named as eligible fuel expenses, and a
Okay.
later FERC rulemaking that established FERC sub-accounts. So the energy
Okay.
charged actually goes to a FERC sub-account that's not mentioned in the fuel rule. So it's kind of just a cleanup item.
So that would be something that SPS, if and when the commission were ever to amend that rule, would need to be included now.
It would provide clarity if the sub-account was listed as eligible fuel expense,
Okay.
yes.
Okay, very well. Okay. And then 2.1 relates to rate cases expenses being deferred, correct?
Yes, ma'am.
And that's for this particular case, right?
That's correct.
If there had not been an agreement on that, I mean, did you initially try to recover that in this case?
Not recover, but we sought the accounting order for deferral, and no party opposed, to my understanding.
So well, I'll go back through these after one more was, 2.2 is the TOU pilot program, correct?
Yes.
And then 2.3 is boilerplate.
Yes.
I believe you referred to it that way.
I did.
So let's go back through these. From SPS's point of view, from your point of view, as SPS's representative, do you believe that the section 1.1 was even contested?
1.1 or 2.1? Sorry, you kind of pointed at the rate case expenses when you said that.
No, let me come back up here. Do you believe that anybody was challenging whether or not the continuation should be approved?
No, I don't believe there was any challenge to that.
Okay. So that's a neutral then. Okay. What about with regard to the treatment in 2A of the PTCs?
There was opposition to 1.2A1, if I can take these one by one, which that first paragraph outlines the stipulated agreement around SPS's retention of the value of solar PTCs before cost recovery commences.
Right.
That was an issue. This term limits the retention period to 1 year, which was a recommendation by one of the parties. And there was an additional term here that, to my knowledge, was not recommended in intervener testimony, but if SPS somehow is authorized to defer the revenue requirement for the self-build projects, there'll be no retention of the value of the PTCs. So that it's kind of multifaceted there, but because that last sentence was not a recommendation in SPS's direct, it wasn't previously contested or otherwise addressed.
Okay.
But the retention generally was opposed by some parties.
Okay. And then the second?
1.2A2.
1.2A2. Yes.
Generally, this was to my understanding, has been unopposed in the sense that all interveners, all parties, including staff, wish to see the value of the PTCs flowed through the fuel factors to benefit customers by offsetting eligible fuel expenses, as opposed to embedding, say, a credit in base rates.
Okay.
Where there was disagreement was on
Is I, right?
right, the allocations.
Uh-huh.
Now I'll say 1.2A2I, the 12CP allocation establishes the jurisdictional allocation for the life of the projects, or at least the period in which the PTCs are generated. The final class allocation method would be determined in our next rate case. I note that clarification because, as you can see in the sentence in 1.2A2, the paragraph before I, the flow through implementation or the rate making implementation of the PTC flow through will be determined in the rate making proceeding addressing recovery of the revenue requirement. So if we're in a proceeding deciding the revenue requirement, inherently there needs to be a class allocation determined at that same time, right, to implement the recovery of the revenue requirement. So the class allocation of the PTC flow through would also be established in that proceeding. So those two line up. This sentence is really reflecting that that'll be revisited in the rate case to the extent the revenue requirement is being decided in a proceeding other than the rate case initially.
i.e. your RPS case.
That's correct.
Okay. Is that 250027?
Yes.
Okay. So then if I could characterize 1.2, A1 and 2, including I, there were concessions on both sides.
Yes, Your Honor.
Correct?
Yes, and particularly with the limitation of the retention period.
Okay. All right. So then let's go on to B1 and 2, the transferability of the PTCs. Can you say generally that the original proposal from SPS was in fact challenged?
Yes, both of these paragraphs are different topics. Both topics were challenged, but the challenge came from different parties. So there was less challenge on the transaction costs and no challenge, I recall, to the 10% cap or the netting of the transaction costs against the PTCs for the parties that supported the transaction costs generally. Paragraph 2, there was more challenge to where the deferred tax asset should be recovered, and then of course challenges on the return. But the challenges to each of those topics varied among the parties.
Right, right. So again, could you characterize B1 and 2 as signatories exercise some flexibility and concession in arriving at those two items?
Yes.
And so then we go on to 1.3, A and B. Those were also challenged, correct?
Yes.
And would you characterize the resolutions as set forth here as as being a compromise, or do you feel like that SPS did most of the compromising on these two items?
No, I think this was a group compromise as well. These provisions really outline how this matter gets moved to the rate case. And you see that with the creation of the regulatory liability and regulatory asset. So it keeps the issues alive, if you will, through the deferral to be discussed in the rate case as opposed to here. And there was compromise to move those items to the rate case from different perspectives, right?
And how does that line up, or what's your explanation of what you explained to me before lunch was the FPPCAC was a rate-making type of proceeding that was appropriate to consider these issues, and now SPS is agreeing to move these issues to the base rate case.
So the rate making item here that's changed mechanisms is recovery of a DTA associated with the ITC if one exists, because the revenue requirement for the battery is not a consideration for the RPS rider. Those are not RPS, that resource is not RPS eligible. So the revenue requirement was headed for a rate case in the normal course of business. The transaction costs were proposed through the fuel factors associated with the netting of the ITC across an amortization period in the factors. But again, we've agreed to move that discussion into the rate case. And then ultimately the DTA, if it exists, the agreement would be that that's recovered in base rates. So the rate making items that have changed could still result in items in the fuel factors, but they'll be decided in the rate case, namely the transaction costs.
Okay, so that doesn't cause you any heartburn then, based on your explanation to me of what was appropriate to be decided in this case?
No, because a decision in the rate case can still effectuate implementation of a rate making decision in the factors. Similarly, to rate case decisions in the past that have made determinations for SPS's fuel factors.
Okay. Section 1.4, the off-system sales margins. This was not the original position that SPS took, correct?
It's part of the original position. SPS proposed to retain off-system sales margins for the new resources until cost recovery started. That's what this provision memorializes. What it doesn't have any agreement on or set a framework for is a margin sharing mechanism once cost recovery starts. So if SPS wants to propose a sharing mechanism in its next rate case, it can do so, and then the parties can take any position there on that proposal mechanism. But this memorializes SPS's proposal to retain 100% of off-system sales margins from the new resources until cost recovery starts. So that's consistent with our direct case.
So with this provision, is SPS feeling any obligation to have the issue revisited when and if in a case it's granted cost recovery?
Yes, because it is SPS's position that no framework exists, and normal course of business would be company retention of 100% of off-system sales margin sharing. So we believe the commission should make a determination to establish a new framework.
Well,
or a framework for the new resources. It's a better way to say that.
Okay. A new framework. I mean, a framework exists right now, right?
If SPS had not proposed off-system sales margin sharing, in this case, it's our position that the default is 100% retention for the company.
Okay, so that's the current practice.
Well, the projects are not in service yet, so there's not a current practice.
For any generation resources that were approved and what, now let me ask that differently. What generation, SPS generation resources have been approved and completed and had their cost recovery determined since 286?
Since 286, I don't think any resources. Certainly the solar projects and the battery projects, inclusive of the long-term PPAs, have been approved, but they have not been through a cost recovery proceeding, only the CCN.
Okay. Yeah, and that's what I was trying to find out earlier. It's like, which projects do you believe would be eligible should the commission choose to allocate any sharing?
The new approved solar facilities, Plant X Solar, Cunningham 1 Solar, Cunningham 2, the SPS battery project, Cunningham 1 BESS, the Wildcat battery project, that's a long-term PPA that was also approved in 2024. And as we discussed earlier, while the Borger LT PPA was recently approved as a new PPA, that's an existing facility on the system, so that would be maintained under the 100% crediting to customers margin sharing from the past.
Okay.
And then
any others?
Every new resource added to SPS's system in the future.
Okay. And I think my confusion with the new Borger PPA had to do with reading that the variable O&M costs are going to be collected differently, correct?
Correct. That's consistent with how variable O&M has been treated in other projects, but for one settlement provision on the original Borger PPA that said variable O&M would be in base rates. So with the new PPA, moving variable O&M into fuel is more consistent with the Commission's treatment of variable O&M for SPS PPAs.
Okay. So how do you characterize this one? I mean, is this one that's, you would consider even, or?
This was significant compromise. There was material opposition to SPS's 90-10 sharing mechanism, and so that is not decided in this case. And again, if SPS wishes to have that a framework for sharing established, it needs to bring that proposal into the next proceeding, the next base rate case proceeding. So we sought an authorization here. This stipulation provision does not provide that, a sharing provision.
So you think this was a significant compromise on SPS's part from its original case?
And the parties as well, to memorialize the retention in advance of commencement of cost recovery.
Memorialize the retention until cost recovery commences.
Yes.
Right, which is opposed by staff, right?
Yes, that's my understanding.
Well, there's have there been other instances where there have been off-system sales prior to cost recovery?
I think so. I mean, generally, an off-system sale can occur once a facility is released to commercial operation, and projects that go into service and then have subsequent cost recovery could be eligible for off-system sales, and then off-system sales margins would be realized before cost recovery starts. And that's, I think, a particular benefit of the situation we're in with the solar, because SPS is not proposing to not serve retail load with these resources immediately upon commercial operation, right? We're not going to hold the resources and sell them into the market, for example, until cost recovery commences. So as soon as they go into service, not only will they be generating PTCs, and once cost recovery commences, those will be flowed through, the value of those will be flowed through the customers, but they'll be positively influencing system average fuel costs because the solar resources are, have no fuel costs associated with them. So customers will be receiving the benefit of the generation on the system, and those benefits will be reflected in seemingly lower, all else equal, right? Lower system average fuel costs before they're paying for the resource potentially.
And if we can look at your testimony and support on SPS 12 of the comprehensive non-unanimous stipulation, I'm at page 22, and you're asking yourself the question posed on line 5. Sorry, need to turn that phone off. I think I've had the phone for 4 years now, and I'm still getting calls for Magdalena. Anyway, page 22, question posed at line 5, why is it reasonable for SPS to retain a portion of its off-system sales margins? And you're answering that question, and then at line 8, you say, if the new SPS resources are not in rates until SPS's next general rate case, comma, there will be a significant amount of time between the benefits of fuel-free energy savings for customers and when SPS will begin cost recovery. That's your testimony, right?
Yes.
So, sort of what jumped out at me is you're claiming that there is going to be, well, I won't say that, but define for me significant amount of time and what your definition is based on.
Sure. It relates to these two retention periods. And the retention periods I'm referring to are the off-system sales margin retention period in stipulation section 1.4 that's on the screen, and then the PTC retention period that was in 1.2. So since the inflection point from company retention to customers is the commencement of cost recovery, the longer it takes for cost recovery to start, the longer the retention period for the company will be. Now, with regard to the retention of PTCs, that's limited to 1 year. But for off-system sales margins, there's not a limitation. So to use the RPS rider example, right? If the project revenue requirement is being recovered through the RPS rider, presumably that rider would go into effect for the 2026 solar projects on January 1, 2026. So the PTC flow through to customers would start then, and SPS's retention of off-system sales margins would stop then, absent another framework established in the next rate case. Comparatively, if the revenue requirement for the solar facilities is in SPS's base rates, with a filing assumed later this year, rates would not be effective absent an interim rate agreement January 1, 2026, right? So the retention period would be longer in calendar year 2026 It would go until the effective date of rates in that SPS rate case. Again, if the revenue requirement is in base rates. That's the inflection period that we're talking about and the timing of the retention for the company versus when these customer provisions would start. And that's fair because it recognizes when the cost responsibility is picked up by customers.
So the difference in the retention periods is you define as significant. Correct?
Yes.
And I didn't think these projects were going to be completed for the COD until spring of next year. Is that right?
Yes, for the 2026 projects, we're anticipating an in-service date in April. But I still think, and parties would agree that even the difference between April and say November or December 2026 effective data rates from the rate case is a material amount of time.
4 or 5 months is now you're saying material. Is that the same thing as significant?
Well, I think it's significant. I was saying I would expect the parties to also consider that a material amount of time. I don't know if they'd consider it material or significant.
So basically, if the projects aren't in operation until spring of next year, and then potentially your new, if you file your rate case in fourth quarter, like you said earlier, and then, if there's a normal suspension, as you say, absent an interim rate agreement, then chances are, it's going to be the latter part of next year. So for you, the difference between potentially April and October, November, is what you're referring to in this answer, correct?
Yes, that's correct.
Okay, so then let's go on to 1.5, and that was the allowance. That really wasn't disputed, was it? Because
No.
of the FERC change?
No, Your Honor, it was not.
Okay. And then what about the rate case expense? SPS is deferring rate case expenses?
I don't
Was
recall
that
opposition to that.
not a big bone of contention?
No.
I mean, the rate case expenses, whenever they're looked at in the base rate case, sometimes is challenged, right?
Sometimes.
Okay. What about the 2.2, the time of use pilot? You're answering your questions earlier that I had, and you explained to me, in addition to what you have in your testimony, the steps that have gone on and how there's been an agreement for a certain customer class, as indicated here, the large general service transmission class, that there's going to be a pilot project in the next rate case. Was this a significant concession on SPS's part to agree to this?
Yes, it was. We've been through the stakeholder group, and there's varying opinions on time differentiated rates, particularly for fuel among the parties. And we, as you know, have testified to some of the technological limitations of being able to conduct a pilot or to implement a rate. So A pilot structure is more appealing to the company at this point in time, particularly because the time of use rate is isolated to one customer class. So if there's going to be any intra or interclass effects, we can evaluate that in a pilot as opposed to implementing a tariffed time of use rate. So the pilot concession and the limitation to LGST is a concession on all parties' part. But again, ultimately, this agreement is for a proposal. In the rate case, it would still need to be evaluated and approved in that rate case.
Sure. No, I understand, but well, I mean, I think it was the last FPPCAC case, right? I mean, didn't I recommend that it should be brought up in the rate case, and then the issue was brought to the rate case in 22-286? So my
Yes, it
point
was.
being, this issue's been around for a number of years, right?
It has.
How, and part of it is the technology with the metering, right?
Yes.
Did SPS get their new meters approved?
Yes, AMI was approved.
Okay. How's that rollout going?
It's in progress. Deployment is not yet completed for all customer classes.
Do we have a anticipated date?
May 2026, I think, is the scheduled completion and deployment.
Okay. So SPS will be asking for a significant amount to put in the rate case that relates to that, or they're already collecting on those.
The commission's approval of that AMI proceeding also authorized the grid modernization rider. So the rider is recovering the investment.
Okay. And then the effect and limit section, nothing new there, is there?
No.
Okay. Okay, so looking at the stipulation as a whole then, from the SPS perspective, you're supporting it, so feeling pretty good, walking away.
Yes, Your Honor, this stipulation provides the needed rate-making determinations and frameworks for SPS and customers, essentially to get to those future proceedings that have been agreed upon for further evaluation of things. It doesn't resolve all of the requests that SPS asked for. SPS kind of put the whole basket of goods into this case that were applicable to the FPPCAC. Different parties had different positions on all of those requests, but this stipulation provides for the items we needed coming into this case when we didn't have a line of sight to exactly where all the rate making determinations that we had originally requested in the CCN be made were then moved into other proceedings. So this gives us the clarity to implement different components of federal tax policy or off-system sales margin sharing at the time of COD, which could and will likely predate the effective date of rates in SPS's next case. And just having that regulatory certainty is beneficial for us, but we believe in the best interest of customers and in the public interest, and should be approved by the Commission.
What if any is the fallback position on this? If the commission were to determine that some of these rate making treatments would be better considered in the context of all the rate making elements contained in a base rate case, is SPS going to bring them all back?
If the Commission were to not decide the stipulation terms, the rate making terms in the stipulation, really what it would be denying is some of these retention periods and those frameworks, as well as the limitations of them. And depending on the timing of cost recovery, could be creating a situation where customers could miss out on the flow through of those tax credits in a timely fashion through the factors.
If they're still there.
If they're still there. So we would bring them back, but it's there may be an opportunity cost of not making these rate making determinations in this proceeding compared to a later proceeding that would negatively impact customers.
Again, more timing.
Yes, Your Honor.
Okay, I already asked you that. Very well, Ms. Trammell, I appreciate your time. That's all the questions that I have for you at this particular point in time. Mr. Dubois, any redirect for Ms. Trammell?
Thank you, Your Honor. No to redirect.
Very well. Ms. Haig, any questions for Ms. Trammell based upon my question?
No, Your Honor.
Very well. Okay. Good. Just wanted to add to that. Don't feel obligated. Very well. Ms. Trammell, you are excused.
Thank you,
Subject
Your
to
Honor.
recall if there's something else or somebody defers a question to you.
Understood.
Very well. Mr. Dubois or whoever has the next SPS witness.
Miss
Ms. Huell?
Hopkins, yeah, Miss Hopkins,
Hopkins.
will be presenting Mr. Malley. If I could just have 5 minutes to step around the corner to set up Mr. Malley,
Okay.
that would be appreciated. Thank you so much.
Very well. We are at 2:24. We'll come back at 2:29 and see if Mr. Malley is ready. So again, we'll recess for 5 minutes. Just remember our YouTube. We'll try that button. Can you hear me, Allison?
I can hear you. And
Awesome.
Madam Hearing Examiner, if you're done with the signatories one, could we maybe stop screen sharing so I can see my witness and questioner better?
Okay.
Thank you.
Is my share off? No.
No.
Stop the share.
Thank
How's
you.
that?
That's perfect.
Okay,
Thank
just
you
let
so
me.
much.
No, just tell me, and you know how I feel about the court reporter. When you
I
say
know.
jump, I say how
How
high.
high? I know. That's because you know I won't say jump.
No, it's
Okay.
because you're doing the you know the heavy lifting here, and we want to try to make sure that you get the best record you can. So we're all going to assist you.
Thank you. I appreciate that.
Well, we appreciate you. Okay, we took a little longer. I'm sorry. I was actually saying hello to my supervisor. And I believe that we have our next witness. We have the new attorney, and we have
Mr. Malley, hearing examiner.
there's Mr. Malley. How are you, Mr. Malley? Good afternoon. You're just going to have to unmute yourself. All right. Let's see. Great. If you'd like to go ahead and present your witness.
Yes, Your Honor. Thank you. This is SPS calls its witness Michael E. Malley. Mr. Malley, could you
Mr.
just
Malley,
identify yourself
excuse me.
for the record, please?
Oh, I missed. I'm Michael Edward.
No,
Malley.
wait, no. Mr. Malley.
Oh.
No, I wanted your attorney just to identify herself for the record.
Sorry about that, Your Honor. This is Marty Hopkins on behalf of SPS.
Okay, Ms. Hopkins, thank you.
Thank you.
Allison, please go ahead and swear the witness.
Mr. Malley, would you raise your right hand, sir? Do you solemnly swear or affirm the testimony you're about to give should be the truth, the whole truth, and nothing but the truth?
Yes.
Thank you.
Thank you,
Go ahead.
Thank you, Mr. Malley. Could you please state your full name for the record?
Michael E. Malley.
And by whom are you employed and in what capacity?
I'm employed by Excel Energy Services as a rate consultant.
Do you have in front of you a document that's been marked as Exhibit SPS 5?
I do.
And can you identify that document, please?
That document is the direct testimony in this proceeding that I filed on behalf of SPS.
And does that testimony have any attachments?
It does.
Can you please identify those attachments?
It has two. It has attachment MEM1. MEM1 contains all the monthly Fppcac filings that SPS has made with the commission during the prior period, which began July 2019 through June of 2024. It also contains the corresponding annual filings that SPS has made with the commission that were filed on about April 30th of each of the following calendar year. The second attachment to my testimony is attachment MEM2, and that contains the revenues and expenses required under this filing.
Was the testimony and attachments that you just described prepared by you or under your direct supervision?
They were.
Is the testimony and the two attachments true and correct to the best of your knowledge?
They are.
And if we were to ask you these same questions here today, would your answers remain the same?
They would.
And there are no known corrections to your testimony or attachments at this time, right?
Correct.
Madam Hearing Examiner, I move for admission of SPS, Exhibit SPS 5.
Mr. Malley, I'm just trying to. Oh, I just pulled up the wrong case. Pulled up your TEP case. That won't help me. Here we are. I just wanted to get a clarification on your attachment 1. Just for the record. Your attachment 1 in the Dropbox is just a memo page, right? You don't actually have the reports, do you?
I have them in front of me here, right next to me right now. I do believe that cover sheet refers to an iShare site where those filings are kept for parties.
Yeah. Well, how many documents are there?
Well, there's the monthlies from July of 2019 through June of 2024, plus then the corresponding annual report. So that would be, for each year. So that would be for 19 through 23.
Ms. Hopkins, where's my documents?
Your Honor, I'm checking on that right now. My understanding was they should be in the Dropbox. Can you give me just a minute?
Yeah, just tell me if I've pulled up the wrong thing in the Dropbox. Okay. See, I don't see in my Dropbox here that I actually have now in his attachment 2, 1 of 20, I've got all 20 pages of that.
Yes, Your Honor, the MEM1 should be significantly larger, a couple hundred pages.
Your Honor, I'm sorry to interject. I think we have discovered the oversight, and we are working to correct it right now. I think the issue was that in their native form, the PDFs and the native Excel documents were quite large. And so there was a slip sheet, and in error, the slip sheet that you see got uploaded to the Dropbox rather than the discrete report PDFs. So we are working on getting that into the Dropbox right now.
Okay.
So it was an unfortunate oversight on our error.
Well, do we want to go to a different witness then? Because I mean, I don't know.
Perhaps because I think that might be best, like for your purposes, if you don't mind maybe going out of order. I think Ms. Hopkins has a couple of the next witnesses, and then I can work with the SPS team and we can get the documents in the Dropbox, and then hopefully they'll be available for you to review.
Okay.
Okay, so I'm gonna
I want to make sure that I just want to make sure that, staff has an opportunity and the other
Right.
parties to have a correct exhibit before I admit said exhibit
I agree with
and
you.
or any questions. Okay?
Yeah, I agree.
Okay. All right. Mr. Malley, stay tuned there till we get your exhibit and your testimony figured out. And we'll come back to you, I promise.
Okay,
And
thank you.
Ms. Hopkins, you want to call your next witness?
And sorry,
Or Mr. Du Bois?
Yes, Your Honor.
Whoever would like to take the next witness?
yeah, two parts, I guess. One,
Okay.
we can do that, but first, I think we do think it is in there, but attached to
Okay.
Exhibit 5 with a number of nested, not a technical term, PDFs there.
As long as it's not that bird that built a nest in my hanging plant. It's hard to water a plant when you can only water half of it. Now, see, I've tried to open that. Are you saying there's more than meets the eye? Copy link. No, I don't want that. Mr. Du Bois, I'm pulling it up and I'm not seeing anything else. Tell me how to find if there's a secret door here to something else.
Can we maybe go off the record for a second
We
and have
can.
somebody who understands the technology to weigh in?
Sure. Allison, we're going to go off the record here for a minute. Remember, we're still on YouTube, but oh, good. Here comes somebody behind you.
Yes.
Hi, hearing examiner Hers. I'm Cindy Baeza.
Hi, Cindy.
How are
Thank you
you?
for all the documents that you sent to us.
You are so very welcome. If you will, on the PDF, when you have the PDF on your screen in the top left hand, where you can make it tiles and see more than one page on your screen,
Okay.
you will see it looks like a paperclip for attachments.
Okay, I'm in Dropbox.
And I did verify from that if you download from Dropbox and open that on your computer, you are able to see these.
Well, I guess I'm just not. I thought I opened it in Adobe.
Do you have Adobe Pro or Adobe Reader?
I'm opening it in Adobe Acrobat.
Okay, you should be able to, whenever you open up your PDF and usually on the left-hand side, you can click and see where you can have like 3 or 4 pages across plus your normal document on your other part of your document. Can you share it on the screen and maybe I can talk you through that way?
Sure. That I can do. Okay. Sure.
Okay, so
Okay.
see on the top left-hand part of your screen, if you it's on your right-hand side. That's what's the difficulty. And what does that say? The one right above it, click on that. There's all your attachments.
Oh,
There's just hundreds of these, and it would take, and so I made a decision to just attach these to his testimony. At the time it made more sense. It takes up a lot less space.
okay.
If you would
Do you
like
have any idea how many pages it will be?
hundreds. Mr. Malley, do you have a good estimate of how many pages?
Sorry, need to unmute. I'm looking at the stack here on the desk, and it's a couple reams. So it could be 1,000 pages.
Okay. Okay, well, that answers that. Allison,
Yes, ma'am.
exhibit wise, have you been following this?
I have been following this, and that was something I was going to look at, was that when I downloaded the exhibits, if I will see that as well. I can't do it right now because I've got several things running on that screen on the computer where I've got that.
Okay, I'm gonna have to think about this. I think I want a list of every attachment that's in there. But my question to you, Allison, is do I need the underlying document or can I just have the
We could mark the list.
And if we have a list of what those documents, what those PDFs are, and you're going to have the exhibit from the Dropbox, and hopefully you can find the little attachments too. Is that going to be enough, or am I going to need a printout of every page?
Actually, Madam Hearing Examiner, I think that's your call. I think that might be, this evening, before we go back on this morning, I will take a look at this.
Okay.
I'm pretty certain I'm probably going to see the same thing you are.
Okay. Okay. Very well. Okay, let's go back on the record. Thanks to Cindy from SPS for showing us how that exhibit worked. And we've had a discussion, or I've had a discussion with Allison, our court reporter, about what we need. And I think from SPS, I'm going to need, I want a list of every one of those PDFs that you can put under the number 1, or, just the little title thing. And it's like, here's the documents that are attached. in PDF format, and let's start with that. And then Allison and I will look at this and see if we need. You're anticipating 1,000 pages. We'll see if we actually have to include all of that for our record. Let me just ask Miss Hopkinson, is any of this confidential?
No, Your Honor, it's not.
Okay. Well, that takes one impediment away, but still, wow. Okay.
Your
All
Honor,
right.
we will put that list together and get it uploaded as soon as possible.
Okay. Very well. I appreciate that. With that, let me just go back off the record 1 second here. For the only witness or the only party, pardon me, that has questions of Mr. Malley other than myself, can you work with this document right now while I'm reserving admitting this with have you clicked the little attachment thing? Can you see all those PDFs?
Yes, I'm only down to like maybe 12 pages in, but yes, but I can see them and I can work with them.
Okay. Excellent. So I guess in reference to your request, let me just ask Mr. We're going to continue with Mr. Malley. Mr. Malley, are the attachments, which are, I guess, reduced to hard copy on your table, as far as you know, are they true and accurate to the best of your knowledge?
I haven't gone through every single page, but I would assume, given it's a pretty big stack, I would assume that all the documents are there.
Did you actually author those, or were those prepared under your direction and control?
They were prepared either by me or under my direction and control.
Okay. And have you read any? Well, I'll wait till let's one thing at a time here. Okay. And the PDF files represent a complete picture of the documents through what time period?
They begin July of 2019 through June of 2024. The monthlies, that's what's contained in there, as well as the annual reports filed with the commission. And so each calendar year is filed on April 30th the following year. So we have those annual reports also included in that.
Through 2023?
Through 2023, yes, ma'am.
Okay.
So these actually are also on file with the commission. Every single one of these as well. We file them with the filing clerk on a monthly basis, and the annual report also gets filed there as well.
And I think or it might be a surprise. I've asked that these be updated through the end of last year.
Yes, ma'am. We'll take care of that.
Okay. Very well. Let me rephrase then the request by SPS.
Excuse me, Madam Hearing Examiner, have you gone back on the record?
Yes.
Okay.
Did I not tell you?
You did not.
Okay.
All
Let's
right.
go back on the record.
Thank
you. Mr. Mallett, we've had a discussion I thought was on the record, but wasn't. And I asked you about the attachments to your testimony that are referenced in the MEM-1. You told me that they are the July 19th through June 24th monthly reports, and the annual report filed on April 30th through 2023. Is that correct?
That is correct.
You also told me that all of these attachments to your testimony have been filed with the commission. Is that correct?
That is correct.
Okay. So basically what we're just trying to decide here that we'll look at later is if we need the paper copies of these things. I'm lending or starting to lean toward thinking we don't. These are collected, I think, for testimonial purpose and ease of reference rather than me trying to find these on the info share. And Mr. Malley, let me just ask you again, are all of these PDFs true and correct? Well, they were prepared by you or under your direction or control?
That's correct.
And you believe them to be true and correct to the best of your knowledge?
Yes, to the best of my knowledge.
And do you ever file any errata or substitute exhibit for these things?
To my knowledge, during this period, there were no erratas filed on these reports.
Okay. Just wondered if they would be included if there had been?
Correct. Yes.
Okay. Very well then. With regard to SPS Attorney Hopkins' request to admit SPS Exhibit 5, Mr. Malley's direct testimony, and subject to my order that all of the PDFs be named and included on attachment MEM -1, is there any objection to admitting the testimony as set forth, subject to a later determination that instead of a listing, there might actually have to be paper copies of each of the exhibits? Hearing no objection, I'm going to provisionally admit, subject to trying to figure out if we actually need the paperwork. Ms. Hopkins, you can go ahead.
Thank you, Your Honor. We present Mr. Malley for cross-examination.
Very well. Ms. Hang, will you have
Yes, ma'am.
questions for Mr. Malley?
I have just a few.
Go ahead, please.
Mr. Malley, I'm very glad we were able to unpaperclip all the attachments in MEM1. I am going to direct you to page 2.
Of my
Of-
test,
Yes, of your direct testimony. So MEM1 is the attachment to your direct testimony, correct?
Mhm.
The ones that we just opened?
Okay, you're directing him to the attachments.
Correct.
Okay, what page of the attachments?
Page 2.
And which document?
In his direct testimony, it's MEM1. That is the attachment.
MEM1 is the page that says located in file share.
Okay. I will pick, let's see. How about it's on my computer, it's showing page 2, but let's go to July 2019.
What number is that?
That is, I am showing from the PDF that I opened, it's 3 of 20, but it doesn't. Okay. Mr. Malley, why don't you, because these are all the same, so why don't you just go to the first report you have in front of you?
Okay, so that would be stamped Rule 550, July 19.
Yes.
Is that right?
Stamped. I am showing that as Southwestern SPS actual fuel cost for July 2019.
Okay, on page 2 of that document?
Yes, on page 2 of that document, which is the
Okay,
Form
go ahead.
550. That's a
Are you
Rule
there,
550
sir?
form.
Let him get there. Oh, I'll share. Maybe. Can we see my share?
Yes, Your Honor.
Okay.
Okay, so we are going to bear with
Your
me.
question, are you there,
Yes.
sir? I've got it up on the screen if you haven't located your paper copy.
so we're looking at the report for July 2019. Okay.
Yes, sir.
Okay, let me
Go ahead, Ms. Hang.
my computer just decided that it doesn't want to hold on. I think the size of the attachment is oh, hold on. If you bear with me for a sec. Okay, let's go to the Dropbox. Okay, it just X'd out. Hold on. I still have your direct testimony open and I paper clipped it and I'm looking at the Dropbox. So let's choose a different year. How about
Can you see the screen on the screen share?
yeah, let's go to March 2024.
Okay, because that was the one you wanted.
Yes, but then I can't it's I can't really see it very
Okay.
well. It's very small. So let's just go to
Okay, March of
24.
Okay.
Yes. Mr. Malley, are you seeing this?
Yeah, I'm trying to go to the actual document in front of me. So you're looking at March of 24.
Yes.
Uh-huh.
And I am on page 2 of that filed report. It is the March 2024 Rule 550 Form 1.
Are you there?
I'm there.
Okay.
Okay, go ahead.
Okay, so line item, the big number 6, subheading K. Do you see that?
6K on page 2, is that what you're referring to?
Correct.
It is.
I'm there.
Yes, okay. It's it's showing on my screen as the New Mexico retail share of production tax credits, Hale and Sagamore. Is that what you see?
Correct.
Okay, and that's some number. Can you show us please how that is calculated?
Yes.
Okay, and go slowly because I'm taking notes and I'm not good at math.
Go ahead, sir.
So I actually have a work paper within that PDF that we can reference that would be helpful.
Okay. Go ahead, sir.
If you go to scroll down further to the last, basically the last page 11 under the support. So you got to get past the first 5 pages. And then if you scroll down to page 11, you will see the calcs. So 11, that is it. Thank you.
Okay.
And then, so 11 and 12 added together roll up to the line item that you referenced earlier in the balancing account.
Let's see. Hold, bear with me. I'm going back to 11. Okay. Okay. I'm gonna try to make this bigger on my screen because okay, page 11. And where do these numbers come from?
Okay, so the first page 11, I don't know if we can go up to that. Okay, so 11 are the PTC calculations, the credits that we flow through the balancing account for the month of March. So the first number that you see, that 0.028, that number comes from the IRS.
Okay.
The Internal Revenue Service. The volumes are from our plant and they come from our books and records. Then as you walk through it, you take the rate times the volume to get you what we call the unadjusted amount of the 5.6 million. And then tell me if I'm going too fast or too slow.
Where is the rate times? Okay. Okay. So let's see. Rate times the value. Which one was that again?
The rate's the top number,
okay.
0.028. So that's the rate that is authorized by the Internal Revenue Service.
Okay.
For PTCs.
Okay.
And then the generated volumes available for the PTC calculation is the next numeric value, that 202. So you take the rate times the generated volumes to get to the what we call the federal PTC amount unadjusted before the gross up, the income tax gross up factor.
Okay.
And then once you apply it, because we're going to flow this through our rates, so we have to gross them up. And that's how we get to the 7.3 million you see as the federal production tax credit amount. And then we have to, that's a total company number. So then we have to jurisdictionalize it and figure out what portion of that goes to New Mexico. And you'll see that New Mexico system allocator takes that 7.3 and then gets it down to what New Mexico retail's portion.
Okay. And where does the system allocator come from?
The system allocator is actually derived too in the spreadsheets, that 44. I can show you, I believe. Let's see if I can. Hang on. Yeah, so that allocator is total New Mexico volumes loss adjusted over total company volumes.
Volume of production?
Yeah. No, it's sales volumes.
Okay.
Yeah. So they're loss adjusted.
Okay.
And then that's where the 44 comes from, the 0.44. And then that's how we derive. So it is an energy allocator, to be clear.
Okay, and going back to the calculation itself on page 11, after doing all the calculations, we get is it 7 million times 0.44, we get whatever it was, 3 million something. That amount, what happens to that with regard to FPPCAC?
So that amount on page 11, and that's for the facility Hale. If you go to page 12, there is a similar calculation for the Sagamore facility. Do you see that?
Yes.
So if you take the allocated revenues from both of those, so you take the 3.246, and then on page 11 you take the amount there, the 3,262,000. Those roll up to that page 2 earlier when we started these questions here on page 2. They show up on in the balancing account under 6K as in kite.
For 6 million.
Yep, 6,509,000. Yes.
And how does that get flowed through the FPPCAC?
It is a credit like all the other credits that you see there. So it's a reduction to our fuel costs.
Okay. Yeah, just bear with me a sec.
So to give you an example, if you go up above our fuel at the very top for the month on 5C, our fuel cost for the month for New Mexico is $30.782 million. And then all those credits that you see, which the PTCs are included, right? That 6.5 you see, along with all the other documented credits, amount to 20,847,000 there, right? Right. So you subtract that from the total fuel, and then for the month, that particular month you're looking at, the New Mexico amount is that 9.9 million that you see, 9.934 for Q2. Yep. So some very significant credits, as you can see.
So for each facility with respect to Hale and Sagamore, what is it? The sales volume for with adjusted for loss. Is that production based, or how does that base? Like, where are you getting the sales volume from?
The sales volumes are GL based.
What is a GL?
What got recorded during the month? What got billed during the month? For the month of March, for example, we're looking at March.
Based on their production.
It's based on sales.
Yeah, but what are you? If you don't produce it, what are you selling?
You were asking me about the allocator, correct?
Yes.
Okay, so the allocator is different than the production volumes we were talking about earlier on page 11 and 12 that the PTCs are calculated. But if you're asking about the 44% and how that's derived based on billed sales, loss adjusted.
Okay, I guess let me re-ask my question. The adjusted, sorry, sales volume what are you selling here? You're selling something to get a sales volume, correct?
So when I'm talking about the allocator and the derivation of that, we're taking the sales, the energy sales that we made to New Mexico as the numerator.
Mm-hmm.
And the denominator is the sales made to Texas and our wholesale customers, all loss adjusted. So the numerator is billed sales times our approved loss factors divided by the total system, which would be the Texas billed sales loss adjusted plus wholesale at loss adjusted, as well as the New Mexico sales loss adjusted. So that's your denominator. And that's how you get to the 44%. And it's an energy allocator.
Is there a minimum system requirement for Hale and Sagamore?
I don't know what that means.
In order to, let me look at something I can see on this page. I wish my screen was bigger, but it's not. Okay. Is there a minimum amount of output that these two facilities have to produce?
I don't know.
You don't know if there's a minimum, okay, all right. I would like to take you to page page 5 of your direct testimony. And I'm just gonna bring that up in my screen. Okay, page 5. I'm gonna close this. Okay, on page 5 of your direct testimony, you go through the 4 steps in determining monthly FPPCAC factors. Do you see that?
I do.
Okay. The 4th factor, where you talk about adjustments for prior months, and you talk about commission approved adjustments. Do you see that?
I do.
Okay. In this FPPCAC application, SPS is requesting proposing new adjustments. Is that correct?
That's correct.
Okay. So I am on paper page number 10 of your direct testimony. Well, actually, not go to 9 because that's where it starts. SPS is proposing in this process any new adjustments, and you say yes, we are proposing the following. And the first one, line 1 on page 10, is SPS requests authorization to retain 100% of non-firm off-system sales margins. Do you see that? Mr. Malley?
I do.
Okay. So with that in mind, let's go back to page 9. There we see a table. It's enumerated as MEM1 that lists the previous adjustments that the commission has approved SPS to adjust. If you look at row I guess, real row 3 from top, the first 17,00044 UT. And it says non-firm off-system sales margin, and there's the little plus sign footnote.
Mm-hmm.
Okay. It says SPS is proposing in this proceeding to retain 10% of off-system sales margins associated with certain resources. So, are you asking for 10% or 100%?
So in this application and in the comprehensive non-unanimous settlement agreement, it specifies what resources those are. And as I understand that agreement, that 10% is being deferred for a decision within the rate case.
Yes, but I'm not asking about the stipulation. I'm asking about the plus sign footnote here.
Yeah.
Because it's a bit befuddling, wouldn't you agree? Because the next page you say it's 100% until cost recovery, then 90-10. But then on this table, it's stated as though 10% is the only thing requested. Wouldn't you agree?
No, I think that they're clearly different. The 100% refers to, let's read through this. It's 100% up to the time that cost recovery commences, is the way it is written on page 10.
Correct.
And then on the page 9, it's talking about proposing on once rates are in effect would be a more permanent 10% sharing.
Yes, but I had to ask you to get that, didn't I? Because it doesn't really say it.
You have a
Correct?
question?
Yes, it doesn't really say it, does it?
Objection, Your Honor, asked and answered.
Well, I mean, just for clarification of the record, this is Mr. Malley's direct testimony, which was filed prior to the stipulation. So, I mean, if you want to ask him questions about he didn't file stipulation testimony. Did you, Mr. Malley?
I did not.
I mean, to be fair, if you want to ask him questions about the stipulation, I'll be happy to pull the stipulation up on the screen.
Oh, no, I wasn't asking about the stipulation. I was asking about the assertion that somehow the proposal was to retain 10% of the off system, when in fact it's actually more complex than that.
Well, you can't testify. If you want to specifically ask him that question, or you can move on.
Yes, I will move on. And Mr. Malley, I am going to direct you to what has been listed as staff's exhibit number PB 3.7. Do you have that with you?
I don't have it. Just hold on. Let's see. Nope. Identify the document, please.
Yes, it is listed as staff exhibit PB 3.7. 7.
Okay.
Okay, let me just, and
And do you have the actual interrogatory yet?
we do not. Mr. Melly, can you see this?
Yes.
Okay. This was an attachment to an answer to staff's interrogatory. It's for question 1-4. Um, uh, are you familiar with this?
I am.
Okay. I just have a question.
Do you know what the question was, Mr. Malley? Since staff can't produce their own interrogatory?
I do recall this exhibit, if that's what you're asking me, Your Honor.
No. Do you know what the exhibit is? Do you know the question you're responding to?
Oh, if I'm familiar with it? Was that the question?
No, sir. Okay. I've asked staff to produce the interrogatory that this is purportedly a response to.
Okay.
You're saying you're familiar with the response. I want to know what the question was.
Oh.
Do you know what the question was?
I do not.
Okay.
All right. I was going to enter this, but I will refrain from doing so because we didn't include the question to the interrogatory. So, okay. All right. Mr. Malley, that concludes my cross. Thank you for your time.
Thank you.
Thank you, Ms. Hang. I just got a few questions for you. Mr. Malley, are you familiar with the testimony of the staff witness, Mr. Brossi?
Which set? I mean, he's
Either one, either his direct or his testimony in opposition to the non-unanimous stipulation. Did you look at those?
I did briefly, yes.
Well, basically what I was able to ascertain this morning. Let me find my note. Let me first ask you, Mr. Malley, were you listening this morning?
Yes.
Are you familiar with the Texas Fppcac case?
Yeah, I am also responsible for filing the reports in Texas, so yes, I am.
Well, basically, it appears to me, if I'm understanding staff's testimony correctly, they seem to be claiming that SPS made a mistake in the monthly filings here in New Mexico. Did you see that when you looked at the testimony?
I didn't recall that.
Okay. They somehow seem to be claiming, and I won't know till I ask Mr. Brossi, but staff seems to be claiming that either through their I think through their research in this case, I think is the assertion that's being made. Through their research in doing this case, they found out about the Texas case, and they're claiming that the result of the Texas case justifies that there's a mistake that's been made in the calculation of the Fppcac. And I believe they're alluding that it has to do with some calculation with regard to Hale and Sagamore. Now, if that is staff's claim, what do you say?
I'm not aware of any errors related to the PTC calculations related to Hale and Sagamore on the monthly fuel filings we make with the New Mexico Commission.
Do you believe that there's been any mistake with the annual filings with regard to the Fppcac that SPS has made?
I have no reason to believe there's any errors in any of our filings whatsoever that we've made with the New Mexico Commission.
Okay. Let's look at page 6 of your testimony when you're answering the section 3 SPS monthly Fppcac factors. And on page 6, the question posed at line 4, what loss factors is SPS currently using to determine the amount of the New Mexico jurisdictional fuel and purchase power to allocate to each of the voltage levels? And you begin your answer at line 7 by saying, for the period between July 19th through August 2023, SPS used commission-approved loss factors from case number 17-00255 to determine the amount of the New Mexico jurisdictional fuel and purchase power to allocate to each of the voltage levels. Is that correct?
Yes.
And then there's a different period of time beginning in September of 2023. SPS began using the loss factors approved in case number 22-00286. Correct?
Correct.
Can you generally explain for the record what the loss factors are and how or why they're allocated at a voltage level?
Yes, that's a really good question and an important question to ask. The reason why we loss adjust our fuel factors have everything to do with the where we serve each customer. There's basically 4 voltage levels. There's secondary, primary, sub, transmission, and backbone. Those are our 4 levels of voltage levels that we serve. And depending on where a customer is on our system will depend on, based on those 4 voltage levels, will depend on how many losses are incurred to actually serve them energy. So if you're a secondary customer, you're a lot further down the line. You have transmission, distribution, you're a lot further down the line per se to get our electrons to you to serve you. So it costs more fuel, if you think about it, more generation to get to serve you. as opposed to a transmission customer that's served at a higher voltage level and closer to the generator, you have less losses. And so really the important thing about loss adjusting the rates is to accommodate for where you're being served and cost assignment to get the proper cost assignment.
And just to clarify for the record, basically the amount of the electricity that's being generated at point A isn't the amount that actually arrives at point B, correct?
Yeah, because you have losses. That's correct.
So yeah, so some of the electrons go somewhere. I don't know.
Yeah,
right?
yeah. Physics. It's there is some losses. Yep.
And I want to look at your attachment 2. Okay. So on page 8 of your testimony, the question posed at line 3, what was the dollar amount of the fuel and purchase power revenues collected from SPS's New Mexico retail customers for the prior period? And you say, as shown in attachment MEM-2, the revenues were 796,087,843, correct?
Correct.
And what page do I need to go to?
Page 20.
All the way to the end.
Yeah, sorry.
That's okay. You had a lot to do to get there. So, okay. So page 20. Okay,
Yep.
There we are.
Yep.
Okay. So where's my number again? 796.
That's page 19.
Yep.
You got one more. Yeah. There you go. Go to 6B as in boy.
Okay.
And there's your number. Yep.
Okay, there's my number. And and where's my okay, so that's the amount that was collected.
Correct.
Okay, where's my expense number?
So there is the expense number in my testimony. If you go
Right
down,
here?
yeah, it's right there, right?
Okay.
So that's an adjusted number, and but yeah, there's that number as well. It's there in the total.
Okay.
Yep.
So then, without me, so where's my difference?
Okay, so if so you've got all these adjustments, right? So as you're collecting, you're truing up 4 months later. So you're getting your revenues
Oh,
in.
is it 4 months, not 2 months?
Well, there's two different lags. The lag on the true up is 4. The lag on the recovery is 2. So
okay.
it's I know it's yeah, this has been that way for many years, but yeah, that's the difference between the two.
Okay.
But your true up between your revenues and your expense occur in the balancing account on items 6A and 6B. So if you look, so we can why don't we just back up to June of 2024 there? We don't have to move. So that June number on 6A that's getting trued up, that 8,000,000, 684, 146.
Okay.
Is actually, when I talk about the 4 months, if you go over to 7B for the month of February, you'll see that number. There's your 4-month lag on the true up. So what we're doing is once we know what we actually billed compared to what we were authorized to collect. So we were authorized to collect the 8,464,000. We actually collected the 8.8 million. So we true that up in the month of June to get to the amount that we actually bill for the month of June, which is on row 10, which in essence, we don't have fuel and base. So 7B and 10 are the same numbers, as you will see. It's actually kind of interesting that we picked the month of June. If you take a look at the month of June, we had negative fuel expenses. We've never had that happen, Your Honor. And that had to do with several factors such as gas prices. We had an annual ARR true up through the SPP market and several other things that created the situation to where we had this extremely large, these large credits flowing through our balancing account that resulted in a credit. We weren't, 7.287 million is what we credited to New Mexico customers that month. Pretty incredible.
Yeah. So then just for general observation, you going back to looking at your 796, 87, 843, and your 765, 170, 631, which just sort of ballparking it's like $31 million difference. If I were asked, well, how long did it take them to refund that over collection? What would I tell them?
Well, they do get trued up, and it's timely, and it's done within as quickly as we have the information available. Yeah. So the timeliness of it is very timely. So as soon as you know what the difference is, you're immediately flowing it through, and it takes 4 months to actually, be 3 months to gather. It's the 4th month that you know what that difference is, and then you flow it immediately when you know it. So it's very
a
timely.
Continuous process.
Absolutely, you got it. Yes.
I think that's all the questions. I think I understand your testimony, Mr. Valley. Let me just ask, just for completeness, did you hear me ask Ms. Trammell about whatever variance was requested in the last FPPCAC case, because it had to do with the winter event, also known as, some people refer to it as the Winter Storm Uri event?
I kind of caught some of that, yes.
Do you believe that the request for I think it was an adjustment and amortization of that event is accurately included in MEM-2?
It is.
Okay. Very well. Ms. Hopkins, any redirect for Mr. Malley?
No, Your Honor.
Ms. Hang, any questions based on my questions?
Yes, ma'am, just very quickly.
Go ahead.
Mr. Malley, in reply to the hearing examiner's question, you stated that you, in addition to producing the filings for with the New Mexico Commission, you also prepare them to file in Texas. Is that correct?
We file the prescribed forms in Texas. Yes.
And to file these prescribed forms in Texas, is there a requirement to calculate capacity factor?
I don't know anything about capacity factor relative to fuel, no.
I see. And I'm going to ask you the same question about New Mexico for the New Mexico filings. Is there a requirement that you calculate capacity factor?
I do not calculate that in fuel, no.
Okay. Okay, that is. Let me just quickly check my notes. Okay, that is actually all I have. Thank you very much for your time. I appreciate it.
Thank you, Ms. Hay. Mr. Malley, subject to your update of the numbers and potentially any questions that might come from that update. Your excuse, sir. Thank you very much.
Thank you.
I think we can take, let's take 5 minutes, and SPS, you can, Allison, is 5 good, or do you want 10?
10 would be better.
Okay. All right. I have down on the phone, it's 3:54. So we'll come back at 4:04 and SPS can present its next witness.
Thank you, Your Honor.
And remember the YouTube? Okay. We are back, I think, from our recess. And I believe SPS will have another witness.
We do, Your Honor.
Very well.
We have Mr. Baumgarten.
Good afternoon, Mr. Baumgarten. How are you?
Doing well.
Awesome. Allison, would you swear the witness, please?
Mr. Baumgarten, would you raise your right hand for me, sir? Do you solemnly swear or affirm the testimony you're about to give should be the truth, the whole truth, and nothing but the truth?
Yes.
Thank you. Thank you. And Madam Hearing Examiner, can we take the previous exhibit off?
Yes, ma'am.
Thank you.
No changes to that exhibit. Okay. Stop the share.
Thank you.
Okay, go ahead, Mr. DuBois.
Thank you, Your Honor. Mr. Baumgarten, do you have in front of you what has been marked as SPS Exhibit 6, titled Direct Testimony of Ross L. Baumgarten on behalf of Southwestern Public Service Company?
I do.
And was this prepared by you or under your direction and supervision?
Yes.
And is it a true and correct copy to the best of your knowledge and belief, with 19 pages of testimony and a consecutively numbered verification page?
Yes.
And no exhibits, correct?
Correct.
And if you were asked the same questions today, would your answers be the same?
They would.
And do you have any corrections or changes to your testimony today?
I do not.
With that, Your Honor, I would move SPS Exhibit 6.
Any objection to what's been identified as SPS Exhibit 6, the direct testimony of Mr. Baumgarten as verified by him here today? Hearing no objection, SPS 6 is admitted. Mr. DuBois?
With that, Your Honor, Mr. Baumgarten's available for questions.
Very well. Ms. Hing, any questions for Mr. Baumgarten?
I do not.
Very well.
Thank you, Your Honor.
Thank you.
Madam Hearing Examiner, I'm so sorry to interject, but I think something may have happened with the viewing of your camera. Like, all I see is the top of your laptop. I don't see your face anymore.
Thank you.
You're welcome.
I don't know. I think you might want to see the bottom of the laptop. But thanks. The new camera is tired. It took a dive off my monitor. I just have a couple of questions, sir. Can you explain the hierarchy? Are any of the other witnesses, do you supervise them, or do they supervise you, or how do you all work together?
Nope, I do not supervise any of the other witnesses or vice versa. So I'm in our accounting organization, so I roll up to our corporate controller, who reports to the CFO. So under our corporate controller, she oversees what I would consider our core accounting function, our corporate accounting team, as well as the accounting teams that I directly oversee, which is our SPS regulatory accounting team, as well as our wholesale transmission accounting team.
So do you have any actual responsibility for the for the filings that are made here in New Mexico on the FPPCACs?
So I'm not directly involved with the filings. My primary role is to provide assurance around the numbers that are incorporated into the filings.
Well, as a CPA within your duties, I mean, do you see actual numbers, or are you giving accountancy rules and regulations on concepts rather than actual numbers?
So it's a mixture of both. So I do provide oversight on accounting decisions and how accounting is implemented. But my team also does record specific transactions. So like on the SPS regulatory side, we handle the accounting for deferrals. So like the regulatory mechanism accounting. But you're correct, assuming there's a large volume of transactions that I do not have direct oversight of.
Well, what is the basis for your answer on page 10 of your direct testimony? Question posed at line 5, do the monthly Rule 550 Form 1 reports for the prior period agree with SPS's accounting records? And at line 7, you answer yes.
Yes. So as a check, when we do the filings for the 550 Form 1 filings, we do verify that the amounts included in that form match our accounting records. So myself having access to the general ledger, where Mr. Malley isn't as familiar with the general ledger as the accounting group is. So we provide a validation of the amounts included in the filings.
With regard to your testimony beginning on page 11, it's Roman numeral 4, tax credit transferability. And you're talking about the tax credits, which you say in your testimony are the production tax credits and the investment tax credits. On page 12, the question posed at line 3, what role does cost-benefit analysis play in the decision to transfer tax credits? And in your explanation at line 9, you say, in general, if the transaction costs incurred in selling the tax credits will be less than the carrying costs associated with the tax credits as a DTA for future use, it will be in the customer's interest for SPS to sell such tax credits. That's your testimony?
Yes.
What do you base your inclusion of the transaction costs being less than carrying costs?
Can you let me know? Can you still hear me?
I can.
Okay, I had an issue. You're coming out of a different speaker for me now. I apologize. Can you please repeat that question?
I can.
Okay.
I just want to know what your basis is in that line 9 through 12 answer on page 12. What's the basis that the transaction costs are going to be lower than the carrying costs?
So the economic viability of it Yeah, I largely get that assessment from our tax strategy group, for what they are seeing in the market for what the tax credits can sell for.
Do you know what's included in the transaction cost?
Right. So my understanding of the transaction cost is largely that there's a benefit to the party purchasing the tax credits. So there's a discount applied to the tax credit on the transaction to make it economically viable. So a portion of the transaction costs just relate to that difference in the nominal value versus the transactional value of the credit.
And are there also some type of legal costs or administrative costs that are also assigned to those transaction costs?
So to the
If you
extent
know,
costs, to the extent costs are incurred, as far as like if there was any brokerage or legal fees incurred, those would be considered transaction costs as well.
but your premise in this is that those transaction costs are going to be lower than, for example, carrying costs usually on the deferred tax asset are the weighted average cost of capital, aren't they?
I believe so, yes.
Do you know how much less?
I do not.
See, I don't know. Or do you have any familiarity when SPS files or an Excel company files what we refer to as a financing case?
I'm not.
Well, those are really expedited 30-day cases, and it's usually got to do with refinancing some type of mortgage bond or paying short-term credit off and whatever. And when I look at those and I see the transaction fees, I mean, they're like percentages, like 1 or 2% or whatever. I mean, there are millions of dollars that have these costs. That's where I'm coming from. It's like, well, what is actually included in a transaction cost, and how can it be lower? So that's why I'm asking you those questions.
Okay. Yep. I understand.
And I know you go ahead and say on the bottom of page 12 that the two forms of costs are the nominal value and then there are administrative costs. I was just kind of hoping to get a idea. Do you have any knowledge at all of whether it's SPS or some other Excel entity of a situation where the transaction costs were actually lower than the deferred tax asset in selling tax credits?
I have not performed that analysis myself.
Okay. Are you personally familiar with any of the treatment of the production tax credits for Hale or Sagamore?
Can you be more specific on like what you mean by treatment?
Well, I think if you were probably listening to Mr. Malley, he went through one of the 550 filings with the staff attorney about how those production tax credits flowed through. And I just wondered if you had any familiarity with those credits also from a accountancy
Yeah,
perspective.
yes, I'm familiar with the calculation of taking the as generated kilowatt hours of energy, multiplying it by the IRS tax rate with the gross up to come up with a value of the PTCs.
And then would you then assert that the way that SPS's treatment and its calculations are in line with your accountant check of the actual numbers and process?
Yes.
It's been too long, Mr. Baumgarten. What are those called? I'm trying to remember my accounting for lawyers class. the 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 specific accountant reference, and it's according to, and I could forget the initials and the number. Do you still do that?
I mean, there are certain accounting guidances that we do reference, including the CFR and ASC and formerly the FASB.
Yeah, that maybe that's what it was, the FASB, and they're designated by numerical number.
Yeah, they would assign numbers to FASBs when they would make accounting rulings.
I think I understand your testimony, sir. Let me just see. That's all the questions that I had for you. Mr. Dubois, any redirect based on my questions?
Thank you. I do not, Your Honor.
Very well. Staff have any questions based on my questions?
No, thank you, Your Honor. Thank
Okay.
you.
Thank you. Very well. That was quick, Mr. Baumgarten. Thank you very much, sir. You're excused.
Thank you, Your Honor.
Very well. We have another witness.
Your Honor.
Ms. Hopkins, you have the next witness.
Yes, Your Honor. Marty Hopkins on
Go ahead.
behalf of SPS, and we are getting Mr. Bogner set up. Just give us 1 minute.
Okay. Okay, how are we doing?
Can
Mr.
you-
Bogner, how are you doing?
I am doing well, thank you. Can you hear me?
I can hear you fine.
Excellent, okay.
Okay. Ms. Hopkins.
Yes, thank you, Your Honor. Marty Hopkins on behalf of SPS. SPS calls SPS witness Michael L. Bogner to the stand.
Bogner?
Bogner, yes.
Bogner. Very well. Allison, would you please swear in Mr. Bogner?
Mr. Bogner, would you raise your right hand for me, sir? Do you solemnly swear or affirm the testimony you're about to give should be the truth, the whole truth, and nothing but the truth?
I do.
Thank you.
Thank you. Go ahead.
Mr. Bogner, could you please state your name for the record?
It's Michael Lawrence Bogner.
And by whom are you employed and in what capacity?
I'm employed by Xcel Energy Services in the capacity of Director of Power Operations.
And do you have in front of you what a document that's been marked Exhibit SPS 7?
I do.
Can you please identify that document?
This is my direct testimony in this case.
And are there any attachments to that testimony?
No.
Was the testimony prepared by you or under your supervision?
Yes.
And is the testimony true and correct to the best of your knowledge?
Yes.
Do you have any corrections sitting here today?
I do not.
Thank you. Madam Hearing Examiner, SPS moves for admission of SPS Exhibit 7.
Any objection to what's been identified as SPS Exhibit 7, the direct testimony of Mr. Bogner? Hearing no objection, SPS 7 is admitted. Ms. Hopkins?
We now present Mr. Bogner for cross-examination.
You want to admit his supplemental?
Oh, yes, Your Honor, please. Thank you for that reminder. Mr. Bogner, do you also have what's been marked as, give me 1 second, SPS Exhibit 8?
I do.
Can you please identify that document?
That is my supplemental direct testimony in this case.
And does that testimony have any attachments to it?
No.
Was the testimony prepared by you or under your supervision?
Yes.
And is the testimony true and correct to the best of your knowledge?
Yes, it is.
And do you have any corrections today to this, to your supplemental direct testimony?
No.
Madam Hearing Examiner, SPS moves admission of Exhibit SPS 8.
Any objection to what's been identified as SPS Exhibit 8, Mr. Bogner's supplemental direct testimony? Hearing no objection, SPS Exhibit 8 is admitted. Ms. Hopkins?
Thank you, Your Honor. Now, SPS would like to present Mr. Bogner for cross-examination.
Very well. And there you are. You moved from the second row to the top row. Any questions by staff?
No, thank you, Your Honor. No questions.
Very well. Good afternoon, sir. I've got a few questions for you.
Good afternoon.
So, sir, when you testified last time in the Fppcac case, were your duties and responsibilities the same?
No. At that time in 2019, I believe it was, I was the Director of Gas Supply and Market Operations.
So your current responsibility then is more varied.
It's different, yes. I've moved into the Director of Power Operations role. I've been in that role for about 5 years now, where I'm responsible for the economic commitment and dispatch of SPS generation facilities to meet customer demand.
So do you have a lot of interaction with directly with SPP?
Yes, my team has daily interaction with SPP.
And when you're summarizing what your responsibilities are in this case, you indicate on page 4, line 1, that you're describing SPS's utilization of system resources that result in power generated from SPS.
Pardon me. I apologize. We are having quite a storm, and I just lost my power and internet and just got back in. And unfortunately, I lost it right as you started to question him. I apologize.
Not a problem. And you have a helper who just shut the door.
Yes.
So basically, I'm just I'm on page 4 of his testimony and asking him about the scope. Yeah, I hear the thunder. I see the dark clouds outside. So who knows if we'll lose ours here. But basically, for purposes of the FPPCAC case, you're describing SPS's utilization of system resources that result in power generated from SPS's owned generation and also purchase power at the lowest reasonable cost. Is that correct?
Yes, that's correct.
And then also kind of one of those additional to the FPPCAC items, you are explaining the rationale, including customer benefits associated with sharing off-system sales margins in support of the original proposal that SPS offered in its application, correct?
That's correct, yes.
And I believe Ms. Trammell deferred my question about control and flexibility in the SPP to you.
Yeah, I recall there was a question that she deferred to me about ability to influence curtailment of renewable resources, I believe it was.
Yes.
Would you like me to?
I'd like you to answer that. And just, and I don't recall if this has come up before, but the my rule is somebody defers a question, you get part of their pay.
All right.
It'll be up to you to collect.
Okay, fair enough. So yeah, I believe that the question was what level of control or what influence does SPS have on curtailment of renewable resources in SPP, considering that we do have to follow curtailment instructions issued by SPP, or set points that we receive from SPP as the market operator to dispatch wind and solar resources or renewable resources, also known as variable energy resources or VERS, to maintain reliability and based on economic, instructions. But at the end of the day, those instructions are the result of actions taken by SPS to offer all of these resources in accurately, to forecast our load and renewable output accurately, which ultimately, if we are forecasting accurately, that will lead to a more economic or efficient dispatch of other generation resources, thermal generation resources like coal or natural gas, for example, plants, to accommodate as much of that wind and solar generation that we anticipate receiving or forecast receiving in any hour of the day. So those forecasts are important because they ultimately result in the commitments or dispatch instructions that we receive for our large baseload thermal generation resources. And to the extent that we have more of those resources on, that can influence how much wind energy we're able to take or solar energy we're able to take into the system, recognizing that we have to maintain a balance between supply and demand at all times. So forecasting is very important. We employ 3 meteorologists that forecast weather and load and renewable output every hour of the day to make sure that we're forecasting that production and that obligation to serve our customers as accurately as we possibly can. So that's an example of one way in which we influence the level of wind that's ultimately delivered to customers, and then by default any curtailment of those resources as well. We also can step in, and if we are given an instruction to commit a thermal resource, a large baseload coal or natural gas fired resource, for example, and then later determine that it's no longer needed, we do have the discretion to shut a unit like that down. And ultimately, then the company takes on the risk of ensuring that by doing so, we're not going to incur a higher replacement power cost of some sort to replace that generator that we just turned off. So the main reason why we might do that is if a forecast or realized production from renewable resources has increased, and we determine that we no longer need an alternative thermal resource on to serve that load, we do have that discretion. So those are some examples of ways that we kind of interact with and influence outcomes in the SPP market every day.
Thank you. I believe in getting the company perspective from Ms. Trammell, and in reviewing her testimony and your testimony, it seems to be SPS's perspective that some of the things that are being done, either with regard to the new renewable resources or new requirements from SPP or other things as you've testified to, fall into that category of above and beyond that you believe entitles you to get an incentive, correct?
Correct.
in page 8 of your testimony, line 8, the question posed, what tools does SPS use to optimize its resources in the IM? And the IM is the integrated market.
Yes, that's correct.
And you say beginning on line 9, SPS currently uses Tesla forecasting solution. Is that related to the vehicle?
No, it is not. It is not the same Tesla that makes electric automobiles. That is
Okay.
a separate company that I actually believe existed before Tesla Motor Company did, that has been in the business of developing linear regression load forecasting models for quite some time.
In a wind prediction model supported by DET, capital NORSKE, Veritas, or DNV?
Yes.
Where or is that company originated from?
It's a European company. I can't remember exactly which country they are based out of, but it is a European company that has developed a number of wind and solar prediction models that, along with other vendors in the industry, that we've been using now for roughly 5 years.
How did you choose them?
We had developed a wind prediction model system, forecasting system of our own in partnership with the National Center for Atmospheric Research, starting in about 2010. And we used that system that was state of the art at the time for about 10 years. And ultimately, at the end of that 10-year period, we decided that it was time to start, surveying the industry again to see if there were other platforms out there that had better software, better models, better predictive capability. And so we initiated an RFP to solicit responses from numerous vendors. Ultimately, whittled that down to DNV and did a trial of their software in comparison to our prior wind forecasting platform, and found their forecast to be more accurate. So we actually moved to their system. Interestingly enough, at that same time, the model we developed in partnership with NCAR, which was then operated for the 10 years that we used it by Global Weather Corporation, notified us that they had been bought by Google and were no longer going to be able to supply us with wind forecasting services anyway. So the timing was good.
Just for clarification purposes, you're on page 9, question posed at beginning at line 5, please provide examples of the generator offer parameters that you mentioned. And beginning at line 10, you say transmission constraints, and then in parentheses, e.g. transfer capability limitation, in paren, cause price divergence between points on the system in the IM, and generation responds to set point signals in the market in real time to prevent exceeding transmission limits and to maintain a reliable system. That's your testimony?
Yes.
So could I simplify this to say that transfer constraints causes a price difference that actually ends up influencing generation?
That's correct. Yes. Those price differentials between locations will ultimately result in changes to set points to move generation around, ultimately to help manage flows of power on the transmission system to within the limits of the transmission lines that we're flowing power on to deliver energy to customers. So price, the LMP price or locational marginal price in the market is the mechanism that SPP uses ultimately to derive set points to tell different generators where to, at what level to dispatch energy in order to manage those transmission flows.
Well, if
Sorry, that
there's
was wordy.
certain I'm sorry. If there were constraints in place, is that going to raise the price?
It will raise the price on the constrained side of the transmission element, and it will depress the price of resources on that are trying to flow energy into that constrained area. So in other words, it's the mechanism through which redispatch is orders are issued to ramp down generation on the unconstrained side and ramp up generation on the constrained side of that transmission element.
On page 10, you're continuing to answer that. And at line 1, you say, SPS also screens for plant equipment issues that can result in a partial limitation or a full outage of units and for any fuel delivery limitations on the SPS system. That's your testimony?
Yes.
Aren't you required to do that anyway as a precursor or condition of providing reliable service?
Yes, that is part of our core, function to deliver reliable and economic power to customers every day, is to monitor risks that are any issues that pose a risk to a particular generator facility and its ability to operate or remain available to serve load. So we do perform that function in conjunction with energy supply or our group that manages the actual operation of all the power plants.
And can't the same thing be said of the next sentence? Additionally, SPS manages offers to both comply with and optimize available environmental permit hours. I mean, you have to comply with certain restraints and regulations, don't you?
Yes, we do. As a function of, again, serving native load customers with power, those statements were really made in the context of making off-system sales, where, for example, when it comes to environmental permits, if we run generators not to serve our own native load customers, but instead to serve an off-system sale, those additional megawatt hours of generation from those facilities will also eat into their environmental permitted levels of operation. So we have to be aware of and careful that we don't overutilize our resources and then run our plants out of environmental permitted hours of operation to make sure that we preserve that availability for native load and to maintain reliability. Ultimately, the number one goal being to serve customers with reliable and economic power. So those statements were really made in the context of how running units in excess of what's needed for our own native load customers and for off-system sales instead may actually impact the reliability or outages of our units or our ability to comply with environmental permits.
And I just want a clarification because I want to know if I'm reading this sentence correctly. I'm looking at page 15 and you're answering the question posed on page 14. Please discuss the nature of generation on SPS's system as well as in the Southwest Power Pool. And you make a statement on page 15, beginning at line 10, in your continuation of answering that question, I note for context in the remainder of my discussion that SPS shares with Texas customers 90% of the Texas retail off-system sales margin, in parenthesis, and retains the other 10% of off-system sales margin, in paren, associated with all SPS system resources. Okay, I understand that part. But the next sentence says, the actions I discuss below regarding the incentives and operational issues associated with off-system sales margins are not hypothetical or undertaken in the absence of margin sharing. That's your testimony, right?
Yes.
So are you saying then that if there's not a sharing, the actions are not going to be undertaken by SPS?
No, I think I'm just stating that we do have margin sharing in Texas, so we take all these actions, we do all of the things that I've mentioned or testified to, and we do have margin sharing in place. So it's not to say that we also would not do many of these activities, again, for the benefit of customers and to maintain reliable and the lowest reasonable cost service we can to customers. But that many of the examples I discuss also kind of relate to off-system sales, and that since margin sharing is in place in Texas, that these are real actions that we're taking, and that they not only benefit native load customers, but are also resulting in benefits, additional benefits, accrued benefits through off-system sales.
Additionally, sir, your testimony at pages 18 and 19, you're answering the question posed at line 8, at page 18, line 1. Please describe the additional risk that SPS can take and mitigate by sharing in off-system sales. And you have like 4 bullet points. You have market penalties, market compliance, fuel supply risk, and environmental compliance risk. And my question for you is, aren't these costs already being recovered by SPS? For example, if you had a market penalty, aren't you going to include that in your request for a recovery from your ratepayers?
Yeah, certain market penalties, I believe, are included in the Fppcac, and we monitor those penalties on a daily basis through post-analysis of operations and our SPP settlement statements, and do everything we can to try to mitigate or minimize the extent to which penalties are assessed. The market compliance related bullet there, any sanctions that would be levied against the company for violation of the SPP tariff or FERC rules and regulations that are monitored for in the market by the market monitor, the MMU unit. I don't believe any of those sanctions would be recoverable or flow through the Fppcac.
Which that's incentive in of itself, isn't it? To make sure you comply, because you don't want to get a penalty that you're not going to be able to recoup, right?
It is, yes. There's certainly a negative incentive there to ensure that we comply with all market rules. I think the purpose of listing these risks is really to highlight again that incentives can can work to just motivate, certain behaviors and align the interests of the company and customers, or help to align the interests of the company and customers in more ways to ensure that we're doing everything that we can to try to manage all of the risks that we face every day on behalf of either the company or our customers.
And I may regret this, but page 25 of your testimony, you're answering the question, is there anything else regarding batteries that requires active management? That's a question posed at line 3. At line, you're answering the question, and then at line 10, you say, SPS believes the mitigated offer development guidelines may require refinement to account for the dynamic nature of price formulation in the marketplace. That's your testimony?
Yes, it is.
Can you tell me what that means?
Yes, I think some explanation here is probably warranted. Thank you for the question. The mitigated offer. So in SPP, first of all, there are rules around the costs or the prices at which you can offer to sell energy into the market, and those rules essentially limit the amount of that by which you can your economic offer to sell energy can deviate from what they call a mitigated offer. So a mitigated offer is an offer price, a price level at which the market monitor essentially will mitigate your offer down to if they deem that you are offering your resource in at too high of a price, and therefore economically withholding energy from the market. So the mitigated offer process that the market monitor will use to establish a reference price for a battery, a mitigated offer price for a battery, will be based on the last 45 days, I believe it is, of actual historical LMP prices in the market at that node. So they're trying to use history, the history of prices in the region of the battery, to inform what we should expect for the next several hours or days around what prices will be in that same area, and use those historical prices essentially to determine what's an appropriate price level to offer your battery in at, so that it charges when prices are low, and that it is discharged or producing energy when prices are high. The company will have the ability, again, to modify our actual offer in the market to reflect what we believe through fundamental analysis and forecasts of prices and conditions in the market to be the most economic way to offer the resource in, to ensure, again, that it is dispatched for the benefit of customers to take advantage of that arbitrage opportunity between low price periods and high price periods. And we don't necessarily think that the historical approach that SPP is taking will always result in the most accurate or appropriate offer prices for these battery resources, because just as on Wall Street, past performance is not necessarily an indication of future returns. So history may not be the best guide for what prices are going to do on any given day. And so that's what we mean when we talk about the dynamic nature of price formation in the market, is that history is not always a good indication of what's going to happen for the rest of today or tomorrow or beyond. and that a fundamental analysis of market conditions is really required to appropriately price and manage the dispatch of these battery assets in the market.
As a member of the SPP, do you get the opportunity to give input on potentially changing those guidelines to point out these things?
We do, yes. So we participate in the stakeholder forums at SPP where these market rules are developed, and do advocate for positions that we think will improve the overall design of the market and benefit our customers.
Why? Your testimony on page 34, the question posed at line 1, how will capital L, capital R, capital E, small s, address project resource adequacy requirement shortfalls? Because, I mean, that was a little scary reading about the decrease, but in the prior testimony, but you say here at line 11, at the end of your answer, natural gas prices have historically shown more volatility than coal prices, in particular during the winter months. That's your testimony?
Yes.
Why is that?
Natural gas, so natural gas is largely being produced, again, as it's also being consumed by end-use customers. There is a significant amount of storage capability for natural gas out there that is used to store natural gas primarily in the summer months for use in the winter months. But there is still a significant change in demand as you go from summer to winter for natural gas, because natural gas is the primary source of energy used for home heating throughout this country. So local distribution companies that deliver gas to homes and businesses for heating, among other uses, see a significant spike in the demand for natural gas on cold winter days. So that drives the demand for natural gas up at times to levels that may exceed the capacity of the producers that are producing gas to, in conjunction with the amount of gas that's in storage, to meet the combined demand for natural gas out there on the market. So natural gas prices, which tend to be traded on a monthly and a daily basis, tend to follow those kind of natural supply and demand fundamentals as you go through the year. And whereas with coal, the primary use for coal has always been power generation, and we also have the ability, or with coal plants, you typically are storing large quantities of coal on site next to the coal plant itself. You might have anywhere from 30 to 60 or maybe even 90 days worth of coal on your pile available to use to help deal with the natural kind of fluctuations in the demand for power that occur through the year. So coal prices tend to be a little bit more stable as a result, because of we just have the ability to store more coal locally for use when we need it to meet those day-to-day changes in demand than we do for natural gas.
And just because I don't believe I got an answer, in your management of the system resources, is there any consideration for a dual fuel plant?
Are you talking about a new dual fuel plant as like a new resource on the system, or?
No, I'm just talking about, I mean, does it get like extra points in your analysis? If you have the dual fuel capability, for utilization in a particular dispatch situation? Like if, for example, if your 3 meteorologists actually agreed that the temperatures were going to be below, a certain time frame, and we had another one of those frozen at the wellhead things that happened a few years ago, because no one thought it was, when the system was constructed, nobody constructed it to handle those kind of temperatures. I just wondered if the option to burn fuel oil played into your dispatch decisions.
Absolutely, yes. So we, anytime throughout the winter or any other time of the year, there can be natural gas supply disruptions, outside of the winter months. That tends to be the time when you see, more risk, like you mentioned, around wellhead freeze-offs or just higher natural gas commodity prices in general. So we always evaluate the economics of fuel oil as our dual fuel resource for those plants that can burn either natural gas or fuel oil. If natural gas prices were to climb or rise above the cost of fuel oil on a day, then we would start blending in and using fuel oil where we can at those dual fuel plants. So that there's always an economic trade-off analysis that's going on a day-to-day basis. And of course, the fuel oil is also there as a backstop for reliability in case there is an interruption of natural gas delivery service to a plant. If we can switch to fuel oil, then that obviously helps to ensure the availability of that resource and maintain reliability as well.
Very well, sir. I appreciated your supplemental testimony. I think I understand it. And I don't have any further questions for you. Ms. Hopkins, any redirect for your witness?
No, Your Honor.
Any questions from staff based on my questions?
No, thank you, Your Honor.
Very well. I appreciate your time, sir. You are excused.
Thank you.
I believe we've reached the end of our first day here, and I think unless there's an objection, Allison, is there any objection? Let's go off the record a second. Is there any objection to starting at 9 tomorrow instead of 9:30?
That's fine with me, Madam
Okay.
Hearing Examiner.
Very well. Anybody have any objection to us starting at 9 tomorrow instead of 9:30? Really want to try to get us as far along and perhaps complete tomorrow if we can. So I think perhaps if we start at 9, unless somebody had made an appointment prior to then thinking we're going to start at 9:30. Okay, I'm not hearing anything, so let's go back on the record. We've had a procedural discussion on whether or not we can start a little earlier tomorrow. There's been no objection, so we're going to start at 9 o'clock tomorrow, and I will log in before that in case anybody has anything procedural that we need to add before we resume with SPS's presentation of its witnesses. Thank you all very much. Oh, no, Ms. Drake, you have a question.
I don't have a quick question, but I did want to let you know that I have uploaded to the Dropbox and sent everyone in an email the corrected direct testimony of Mr. Gorman. So
Okay.
please let me know if you can't open the attachment or you don't see it in the Dropbox.
Okay, very well. And Ms. Huell, you also.
Yes, I just have one matter to ask you about with regard to one of your bench requests regarding the updated figure for the 2024 fuel and purchase power cost percentage. We do
Yes.
have that value for you right now that I could give you, or would you just prefer to have it in writing in the bench request?
Yes. Yeah.
In writing?
If you could,
Okay.
just, yeah, that way we can do that formally, and then I can query the people being the parties about whether or not they're going to have any objection or any question pursuant to the rule.
Okay.
Yeah. So if you would just file that, that'd be good.
Thank you.
Okay. Very well. All right. Well, thank you all very much. Appreciate your attention, and we are going to be recessed until 9 o'clock tomorrow morning to continue. And again, try to log on at least 10 minutes ahead of time to test out your equipment and make sure that everything is working. And with that, thank you all very much. And we are recessed until 9 o'clock tomorrow morning.